I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial, Daddy.
I want to give a big shout out to the 13th Jury Podcast and Brandy.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
Yes. And then I just looked to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, want some coffee?
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Good morning! Good morning, jurors. Hello, 13th jurors. Hello. Hello. Hello, how are you? How are you? Hello. Bev is already annoyed. She's already annoyed. It ain't even started yet. She's already annoyed. Hello. Hello. I have missed y'all. Oh, have I missed y'all? I have missed you. Gosh, I feel like I haven't streamed in so long. Other than showing y'all the snow when it snowed. So other than that, aside from that, I am so glad to see y'all though. There has been so much going on. And I got to chat with some of y'all a little bit before we got started. And so I cannot tell you how many emails and messages and DMs I have gotten asking me about the last podcast series that David Marshall, not David Michael, don't know who Michael is, David Marshall Murdoch. I cannot tell you how many. So let me set the record straight on the bonus episodes that I did for y'all with the actual full testimony that, by the way, I didn't even know that he took the stand. You remember they started, I should have taken my medicine. Oh, it's going to be unmedicated brandy today. We're going to see how it goes. If you remember, we started watching that trial. When was that? I don't even remember. It was whenever it was. We started watching that trial, and they had 2 days of it that streamed live, and we watched it. And it was the Getting Rid of the Devil trial is what they were calling it. And David Marshall Murdoch in Florida, because you know it's always Florida. You know we get wild down here. He went and to his ex-fiance's best friend's house where his ex-fiance was in town staying, and shot and killed his ex-fiance, and then shot her best friend in the face. But the best friend survived and then testified against him. And after he shot them both, he called 911 and told them, it's an emergency. You have to come. I just shot 2 women. Sorry, I had to get rid of the devil. So, okay. So then he pleads not guilty. Sir, you done told on yourself. It's a little late for not guilty, but okay, we're going to go with it. We're going to see what he says. I thought it was going to be kind of an open and shut case. However, they only played the first 2 days. They streamed the first 2 days live, and we got to hear Sanda, who is the best friend. We got to hear her and see her on the stand testify, and we were girl powering her. We were like, yeah, Sanda, go, because she got up there, and the prosecutor asked her, like, do you know what happened to you? And she's like, I got shot in the face. And he was like, do you know by who? She was like, yep, that man right there, David Marshall Murdoch. And she was like, oh, Sanda, oh, it gives me chills. Sanda is a survivor, and she got up there and she did her thing. So we watched this, right? And the first 2 days were really interesting and, and kind of crazy. And then all of a sudden the trial was gone. They didn't stream the rest of it. So we're looking for it, and we're like, what the heck happened? they didn't stream any more of it. Well, I didn't think much of it, and then we ended up looking to see what the verdict was, which I think we all kind of knew what the verdict was going to be. I did not know that he took the stand. So all of a sudden, I'm like, you know what? I think I need to do a podcast episode, or however many episodes. Most of the series on season 1 go anywhere between, there's a couple of them that are 1 episodes. Most of them are between, 2 to 7 episodes, depending on how in depth it is. So I was like, I'll do it. So I put in some requests. I got the transcripts for the trial, and I'm sitting there reading the transcripts, and I'm like, whoa, buddy, he took the stand. He didn't just take the stand once. He took the stand twice. And what he said is not where the prosecution was going with that. So I'm sitting there reading, and I'm like, oh, he did not. He did not. It was crazy. So I was like, yep, I have to do my podcast episodes on this. And then as I'm reading, I'm like, oh, I know my jurors. I know y'all, and I know your hearts, and I know that my jurors are just as nosy as I am, and that y'all would want to hear every bit of it. So I was like, I can't exclude, because this isn't one where I can put out my episodes, and then if you're interested, you can go watch the full testimony. There's no way to watch it. So rather than you having to go through more than 3,000 pages to read to get to what you wanted, I was like, you know what? I'll just do a couple bonus episodes with the full testimony. So I did that. And the cross-examination, oh, y'all should have heard me reading it. Did y'all I was getting into my lawyer voice too. I was putting myself in that lawyer's position, because I was mad at him too. I was mad at David Marshall Murdaugh, just as mad as that prosecutor was. And so I'm like, I'm reading it, and I was like, are you saying this? And I was like, look at me getting all into character. Ooh, it was interesting, very interesting. So if you haven't listened to those, I got to play the part of a lawyer. I also played the part of David Marshall Murdaugh. And y'all, he is deep voice Brandy is winner chicken dinner. I was like, okay, how am I going to differentiate between, because I couldn't get Chat Daddy to do it. All of these episodes, by the way, within the last 3 weeks, have been recorded between the hours of 10 p.m. or 9 p.m. and 4 a.m. because they were doing hardcore construction at as soon as they finished the condo 2 doors down, then they started on Mr. Bill's condo. Well, it was Mr. Bill's condo. So I couldn't record during the day, so I could only record at night. So I was like, how am I going to differentiate between these? So I used a voice changer for the parts of David Marshall Murdaugh. But it's funny too, because his voice, he is some backwoods country, y'all. So when I'm reading his parts in the transcript, I got into his script just as much as I did the transcript from the attorneys. I went full force. So it was it is what it is. But it was super interesting. I knew that y'all would think it was super interesting too. So if you haven't listened, there's the 3 main, the 3 actual episodes in the series, and then there's a bonus episode for week 2 of that series, and there's a bonus episode for week 3 of that series. The bonus episode for week 2 is the entire direct examination, and then the second bonus episode for the 3rd episode in the series. The second bonus episode was his cross-examination, and then the second time he took the stand. And he addressed Sanda, and I was like, Sanda gonna come across that courtroom at you? Ooh! Ooh! It was crazy. It was good. It was, I really wish they would have streamed the rest of that, but, they didn't. So, let me get some stuff here that I've missed, because I haven't seen y'all in so long. Regina Crawford, member for 19 whole months. Jury duty tomorrow. I will miss you all. Oh, we will miss you, Regina Crawford. Breezy, member for 20 whole months. God, it's been that long. In case it's gone tomorrow. Best almost 2 years. That's crazy, right? Regina Crawford gets a membership. Thank you so much. Thank you. Thank you. Silly Pig, hello. Taste the biscuit. Oh, God, we got to get back to that today. Taste the goodness of the... Did I show you my Taste the Biscuit t-shirt that my mama got me for Christmas? I wore it on stream one day. I can't remember which day. It's hilarious. Silly Pig, thank you. Now that song's stuck in my head again. Georgia Mom, new member, welcome back to the crew. Queen Oliver Than, member for 21 months. Amanda Davis, member for 20 months. Hey, girl, hey. Hello, Denise. Hello, it's good to see you. Member for 20 whole months. Pretty sure I'm really close to 21 months now. I know. We're going to get back to streaming soon. I'm almost caught up with a lot of the stuff I have to do, and we'll be able to get back to streaming. Well, of course, when Karen Reed comes, I'll be streaming every day, but I'm probably drinking every day. Ricky Watson, hello. Cowboy family is back. Heck yeah. 21 months, Ricky Watson. PJ, hello. Hello, PJ. Member for 16 whole months. Red Pen, 20 whole months. Am I the only one that says that? Because I've noticed that y'all, when you put your birthday chats or anniversary chats or whatever you call them, friendiversary, your little green stuff, when y'all put those in there, I notice that y'all say now 20 whole months. Is that because I say it all the time? Am I the only one that says that? Is that a weird thing? Is that weird? Am I weird? Don't answer that. Happy anniversary, memberversary, birthday, etc. Ivan, hello. Hey, stranger. Hope everyone is doing well. Hello, Ivan. Hello. Oh, Ivan. It's good to see you. Hello's mom. Hello. Deep voice Brady's when I wearing chicken dinner. Yeah. Voice changer for the win. Somebody actually said that the voice changer was like nails on a chalkboard. I was like, look, sis, I'm doing the best I can here with what I got. The good Lord didn't, bless me with a baritone voice. It's probably a good thing, right? Winnaboo, member 13 whole months. Nice to see you, blonde girl. Missed you. Who's that blonde girl? Who's that blonde girl talking? Why's she talking? Why's that blonde girl talking? Thank you. Candace Hoffman for 18 whole months. Love seeing your smiling face. I love seeing your smiling face. Profile. Picture. You know what I mean. Glad you're here. Melissa. Hello, Melissa. 9 whole months. You got a juror, baby. Oh, how we've missed you, Brandy. It's so good to see your beautiful face. It is good to see your beautiful face profile picture also. It just doesn't work going back that way. It's good to see you too. How's that? Megan Easton. Hello. Megan Easton, member for 20 whole months. So excited to hang out today. I am excited to hang out with y'all too. I'm just like some Aunt Bev. I'm already pre-annoyed, but we're going to get through it. We're going to get through it. The episode this coming week will be all things Karen Reed. So I've got to get, we're getting back towards, since we're getting closer to the new trial, it looks like I'm going to have to put a halt on some of the jury duty episodes on some of the other trials that I'm covering, or episodes I'm doing on the podcast, and it'll go back to all things Karen Reed here shortly. So it was a fun little break while it lasted. Zach, hello. It's one of my medium favorites, little chatters. My New Year's resolution were to stay offline all of January and stop super chatting. Hope your Navy SEAL, by Navy SEAL you mean Green Beret, and your mangy mutt, you mean most precious dog ever, are all doing well. We are all doing well. I appreciate it. Thank you. You did not do very well on your resolution, but that's okay. It's the last day of January, so you're close enough. Tosh, member for 20 whole months. Happy 20 month anniversary. Happy. Did you see this? Wildlife officials rescued a 525-pound bear hiding underneath a home from the fires. 525-pound bear. 525-pound bear. Are you covering the trial? Yes. Yep. You'll be all right. Oh, she had a whole husband. Yep. She had a whole husband. Dramonique had a whole husband. She had a whole husband at home. I guess I do say whole a lot, don't I? It's okay. Hello. I'm happy to see you too. Hello. Auntie Bev size incoming. I may give Auntie Bev a run for her money on the size, the annoyed size this go around, because I'm already pretty annoyed, y'all. Here's the thing. This is one of those trials where every time you think you've heard it all, something else comes up. Speaking of which, before we get into Karen Reed, I just want to talk to y'all about everything. I just miss y'all. I just want to talk to you about everything. When I first started the podcast episodes were just the audio version of the recap videos that I was doing, and the very first ones that I did were Letitia Stout. Latisha. So when I started, that's when I was just doing recap videos. When I started live streaming, Lori Vallow, and that was, the construction's about to start. So whatever y'all hear, I apologize. Here, maybe I have my audio reduce mic background noise. Let me see if that helps. Maybe that'll keep y'all from hearing some of it. Anyway, when I started streaming Lori Vallow, I did not get to finish all of the recap videos, but anyway, so for reasons that I will announce later, I am going back and redoing some of those first episodes. And Letitia Stout is the first series that I did. And it was a 6-part series, and I've redone the whole thing. So the audio that was on those original episodes is from the video. So the videos are still like in that playlist on my YouTube. But I have redone that entire series. There's 6 episodes now, and I will have the 7th and final episode, because I'm adding one to the series. The 7th and final episode will be out sometime possibly next week, maybe the week after, because I know next week's going to be most of my stuff's going to be Karen Reed. Because there's going to be a Conspiracy and Canton episode next week. So, anyway, listen to those. It starts with season 1, episode 1. Listen to those if you want to, and let me know what you think. So instead of just the recap of what happened and who said what during the trial each day, I went and I took all of it together and then laid out the entire thing and wrote it how I did all the other ones, like as a full story, telling the full story, and still clips of the calls and all that. So, yada yada yada. Ugh. I still get mad when I hear her. She's awful. But anyway, listen to those if you want to, and let me know what you think, because there's been a lot of work. You know why the Letitia episodes are so much work? Not only because, where's my phone? Not only because there's it's like 20 days of trial or something, but because if you watch that trial, then you know how she how do you even explain what she did? It was like, it's not technically word salad, because like that's like a very specific term, but it was almost word salad ish. She was so annoying, for lack of a better term. She was very scattered in how she would tell stories, and she was very nothing that she said made sense. She was constantly contradicting herself. She was constantly lying, hence the name Letitia. She was just awful. So she's getting through her calls trying. Okay, so imagine like if you have, like if you ask somebody a question and they tell you that answer, talked in circles is the perfect way to say it, yes. If they answer the question, but they answer it with, like, you only need one sentence to answer it, but they answer it with, like 4 chapter books, that's how she was. And getting through those FBI calls was torture. Because you're having to, like, sweep away all the extra nonsense to get to what she's actually saying, because she's so verbose. She gives so much wording, so many words, all the words. She says all the words, but doesn't actually say anything. So to get through all those, and then to go through the interviews that she did with the doctors, it's, oh my gosh, y'all. It's a wonder that I'm not more batshit crazy. She was John Thomas in a jumpsuit. That's true. Dean Sparks, it's good to see you. Oh, look who's here. Hey, Nanny. Hey, Nanny. That's my nanny. Everybody say hi to Nanny. I love me some Nanny. Nanny's been in town. She's been living that beach life for the last couple months, and it's been amazing. Love having my nanny here. Y'all know I talk about my nanny all the time. There we go. Okay, I'm gonna get this pulled up. I guess we lost track of time. We've lost track of time. It's been this morning has just gone by too fast. All right. But I feel like I haven't got to see y'all in so long, so I have to tell you everything that's been going on. Let me get the feed pulled up. Oh gosh, I'm already annoyed hearing Brennan's voice, but that's okay. We're going to get through this. We're going to get through this, and it's going to be a good day. Present. Share screen. Here we go.
I think the clerk is looking for it.
Yeah, I'm giving you.
I'm printing.
I'm giving you, there we go. Oh, I thought that was my audio. Oh, that sounds bad. Let's mute that for a minute because that sounds really bad. Hopefully they'll get their mic together. I'm giving you Lucy Cam down here. Somebody asked for proof of life, so there's your proof of life. Let me turn this down some. It sounds so bad. The bench trial? No. What bench trial? Oh wait, the bench trial, is that the socialite? I don't know anything about it other than I think just that it's the socialite. See, yeah, all I know is that there's a socialite and it's a bench trial. That's literally the only thing I know. I know absolutely nothing else about it. Is it interesting? A lady got in an argument with her ex. He had a heart attack and she's on trial for his... What? How? 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 Is there like more to that? That's got to be... Oh, Massachusetts. Ooh. Ooh, Massachusetts. I'm working on a little big collaboration right now. I'll tell you more about it later. But with the Karen Reed trial coming up, and the person I'm working on the collaboration with asked me if I wanted to go to Boston to cover the trial, and I was like, I don't. Based on what I know about Canton, no cell phone whatsoever. Hear ye, hear ye. Based on what I know about what happens over there, I was like, you know what? Of all places that you feel safer, I feel safer in Florida. So, yeah, hard pass. She didn't do CPR. That is, so she... So, is she like a first responder? Or, well, she's a socialite, so... Yeah, that's a no for me, dog. Yeah. So that one. Can we talk for a second about this lady's hair? She has fantastic volume. Good for her. Hello, Lisa Dempsey. Hello. Oh, she didn't do it right away, but she did end up doing it. The CPR. Sorry, unmedicated Brandy. I know I'm bouncing back and forth between 4 conversations. Go with me. This is just how my brain works. So she did end up doing CPR, but not right away. So she's being charged with murder. Ooh. Bliss. That's a little bit terrifying. Is this the right boyfriend? Melanie's covering the bench trial. I'll have to watch it. I'll have to watch it because that sounds really... Wow. Oh, hey, Breezy. Yes. OMJ, thank you. I need to drink my meds and drink my juice. By the way, I love that stuff. I do too. Oh, I need to have mine. I didn't take my meds, but I do need to take my Magic Mind. I love my Magic Mind. And they're one of my sponsors. And like they're one of my podcast sponsors, so I do get like they pay for me to do ads on the podcast, but I do not get paid for them, like by them to do ads or endorse them here. So I am telling you right now, that stuff is miracle worker. Breezy tried it. Breezy loves it. I got Chat Daddy taking it. My best friend and her husband take it. I love that stuff. It makes such a difference. Such a big difference. It helps with mostly my focus, but also my mood. I want to double up during the Karen Reed trial. Do you still have to take your meds? I still do. Hey, AJ. But honestly, I don't take them as much. I don't take them as much as I used to. Now, if I don't take my Magic Mind, then I absolutely have to take my medicine. I need to go. I haven't taken either this morning because I'm functioning on 2 hours of sleep right now. So we're going to see how this goes. But I'm telling y'all, Magic Mind, it is so good. All right, let me turn this up since I got their microphones figured out. Hey, 80s. Henny McGee bench trial with Canoni. Allegedly pushed, slapped him knowing he had cardiac issues, recent stroke. Daughter testified against her, but was wish-washy. Victim ran. Oh, okay. Very interesting. You said, okay, what do we think about the beard? Y'all know I love a beard. I always say that I haven't dated somebody without a beard since I was in 7th grade.
Oh, hey, David.
No, I have not found him.
Okay, so I've been working on, I did the David Marshall Murdoch, of course, episodes. So that series is out. And then I redid the entire Letitia series, which I'm really glad I did, because going back and rereading or rewatching a lot of that stuff and then like going through the transcripts and stuff, there's so many things that I forgot and things that I didn't even catch the first time. So I'm really glad I redid that one. So I've been working on those. But this coming week, I will have the next Conspiracy in Canton episode. So it'll be all about all of the new motions, everything that's been filed, my thoughts on them, recaps from all of the things. You know how we do. You know how we do.
Have another transcript on the way up. Laura's bringing it, and then there are. Did we attach both reports to the motion? We have 2 reports attached to the motion. Should I give you separate copies for exhibits?
Okay. Yeah. Okay. Yeah.
You want to talk about the...
She's gonna find it. She's gonna see if she can find the explanation. I remember an email.
I can go to Letitia for a attorney and pick up something new every time. Let me tell you, I do too. So, like I said, my original episodes on Letitia were all just the audio from my recap videos. So I listened to those, and then I went back and rewatched in double speed.
No cell phone use whatsoever. You can do it sidebars and breaks. I don't want to see your cell phone out at all. No cell phones.
Okay, that is the best accent ever. No cell phones whatsoever, even during sidebars. I love that. That is one thing I've missed about this. That and hear ye. And the only fan. Hear ye. God save the Commonwealth. Oh, did you realize you put those episodes in the Conspiracy in Canton section? No. I'm glad you said that, because it automatically, the way that it's set up is it automatically will Let me change that now while I'm thinking about it. It'll automatically upload them to my, everything from the podcast automatically goes to my Conspiracy in Canton folder instead of the podcast folder, and then I have to go through and manually change them. So let me do that now. Thank you for reminding me. Y'all keep me on my toes. Which ones? Just the Murdoch ones are the only ones I haven't fixed yet, right? Okay, now it should be... Alright, now it should be fixed. Hello, hello. Oh, I love me an accent. Hear ye, hear ye. God save the Commonwealth.
I thought he was going to do it for me.
How to rate the podcast. There is on, I'm not sure how to do it on Spotify. On Apple Podcast, if you go to the podcast page, there's like a thing for reviews. It's funny because most of the reviews on the podcast are really good. But you know what's funny is the ones that are like the 1-star, you're the worst podcaster ever. So much of it is like complaining about, like there was one that was like, you have no credibility because you interviewed Turtle Boy. And then there was some that were like, you know, how I'm a fraud because I am not saying that Karen Reed's guilty. And like all of the bad reviews are all like the anti-Karen Reed hater people. I love that for me. So fun. So fun. Yeah, they're on YouTube. They don't load to YouTube until I don't even know how long after. So I know that they're on YouTube, but I don't know how long after they're uploaded to like Apple and Spotify and all that. I don't know how long after that they load on YouTube, but they do load on YouTube as well. They load pretty much everywhere. Everywhere you get your podcast, as they say. Hello, hello. Happy to have you here. Who's that blonde lady? And why is the blonde lady touching buttons? I'm not pressing any buttons today, y'all. I'm going to behave.
Are not on at our table with the TV people.
Just a reminder, folks, on cell phones, please. Make sure that on the silent mode, please. All cell phones, please.
It's under the table,
Here we go. Hear ye, hear ye.
Thank you.
Stop pressing buttons. I'm not pressing buttons this time.
There's unrecognizable faces. That's fine.
Yeah, I'll go over all of the new stuff in the next episode. If I can't fit it in one episode, I'll do.
I'm gonna pop first this morning if you're okay with that.
I'll do 2.
These are small.
Did you guys?
Ruby says I listen to them through YouTube. I need to start setting reminders to move them to the right folder.
Right. Yeah. And then I don't know what the order the rest of the stuff is going to be. One of the judge ones.
What's today? 1/31/25. Let me get my notes ready. Stop pressing buttons. Can we talk about Alessi for a second? I will tell you, he is something else, isn't he? He is a good attorney. My lash girl got her mom listening now, so my lash appointments are Brandy Churchwell 13 Juror time. That's so funny.
You are unmuted. You are muted.
Lally. Alessi is now my favorite. You know what? I'll say this. She has some amazing attorneys, and they are all good in their own specific way. Like, Alessi is very to the point with his arguments, and he's very thorough, and he does a great job with that. Jackson is like the charismatic storyteller one. Yannetti is the likable local, you know, and then of course her appellate attorney I was obsessed with him. He did such a great job. Like, you know, his arguments were so zoned in on the laws and, you know, case law and everything. And Alessi with the case law too. During that Daubert hearing with Dr. Russell, I was like, oh, buddy, he did such a good job. I love watching good lawyering, and they got that going on. Yeah, I put in the full quote because in the last hearing, you know, Brennan quoted my interview with Dr. Kinsey, but he left out a lot of it. So in the last episode, I put some of the rest of that. It's funny too, because I texted Dr. Kinsey. I was like, Dr. Kinsey, they just quoted what you said in this hearing from the interview I did with you. He didn't know. He's tried to stay out of the whole Karen Reed thing because y'all know how people get. Watching other trials, people always saying, I miss Lally. No. Watch him for 5 minutes and zap yourself back to life. What, if anything, makes you want to pull your hair out listening to Lally? Are you going to be covering any new trials? I will be. And I think after next week, I think is when I'm going to be able to. It might not be it won't be a long one. But there are some coming up. I've just had so much going on. There's so much going on. All good things. Oh, you know what else I included in the Letitia episodes this time that wasn't in the recaps that I did? Like her escape charge and some of the stuff she did, like some of her bad behavior stuff, leading up to the trial. Kevin says, nothing excites me more in a hearing than a Karen Reed hearing. They're, yeah. Do y'all think that they're going to delay the trial? Let's do a poll. People keep asking me that. You know, Bev didn't want to delay it the first time. It was supposed to already have been, it was supposed to have started a few days ago. Do you, but there's still so much going on. Do you think the trial will be delayed again? Oh, I need to binge watch the Letitia stuff. I missed it the first time around. Yeah. I watched it, of course, the first time around, but rewatching it after all this time, gosh, after it's been almost 2 years. Rewatching it, it's crazy. I saw so many more things that I didn't catch the first time, and then things that I caught the first time but had forgotten. Ooh, Letitia. Ooh. It needs to be done within a year unless the defendant... Why did it stop? That's not mine. That's something on their end. Unless she waives her right to have it. Because, like, think about, like, Melly. Oh, I thought Melly was bad. The trolls from Melly were bad until this one started. But think about Melly. You know, that was a hung jury, and they still haven't retried him. That's a whole nother mess. Prosecution in that one is a mess.
We may not be that person. Oh, thank you.
Laura, do we have a copy of Ian and Jessica's report that we admitted as exhibits in the file, just in case you want it separately? Thank you.
The M word. Hello. Yeah, the Melly trolls were really bad. You know, it's funny though, because I have said that the Melly trolls wanted to ruin your day, but the Karen Reed trolls want to ruin your life. There's Yannetti. Reed trolls want to destroy you. Boy, have they tried. Bless their hearts.
All right, to the board, please.
Hear ye, hear ye.
Hear ye. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, Unified the County of Norfolk.
Y'all can hear, right?
You shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge, this is 22-117, the Commonwealth versus Karen Reed. Can I have counsel?
What is happening? Look.
Good morning, Your Honor. Hank Brennan for...
Hold on, I might have to change feeds.
Morning,
or is it
Mr.
all of them
Jackson.
like that?
Morning, Your Honor. Robert Alessi on Good morning, Mr. Yannetti. Good morning, Ms. Reed. Oh, good morning, Mr. Bertsche. Okay, let's see. So we've got several matters for this morning that I want to discuss. So first, there's filed a motion to recover expert-related expenses from the Commonwealth, and we'll discuss that in some manner at the end of the hearing today. We've also got Mr. Bertsche's here on Ms. Voss's opposition to the notes. And then there's the Commonwealth's motion for reciprocal discovery pertaining to the employees of ARCCA. And the last one is the Commonwealth's motion to exclude witness Richard Green's debunked opinions. So those are really in that order, except I think we should start with the non-party Gretchen Voss's motion to reconsider regarding the notes. And I do want to say that I received this morning a motion to file an amicus memo. The signatory is Mr. Albano. I've received that. I will allow that to be filed, and I've read the motion and the memorandum. So I will hear you, Mr. Bertsche.
Good morning, Your Honor. Rob Bertsche for Gretchen Voss. I'd like to start by just
Gretchen Voss's attorney.
Taking the time and giving me the opportunity to revisit
Sure.
the court's ruling of December 5. That ruling allowed in full the Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss or Metro Court. Ms. Voss and Metro Court complied with the court's order for production of documents on January 2nd by producing to the court all of the responsive materials, the unredacted tapes and the text messages that involved on-the-record communications by Voss with defendant Reed. I'm here today to implore the court to reconsider that part of its ruling, but also would require Gretchen Voss to turn over her handwritten notes of an interview with Reed that the parties had agreed in advance would be off the record. What's in those notes is really a black box. The Commonwealth has provided no information indicating what it believes the notes will reveal, or why it has
You are unmuted.
particular reason to delve into them. So the question before the court is whether the Commonwealth should be entitled to forage through this reporter's notes and compel her to break her promise of confidentiality with the source in the ungrounded hope of finding relevant and material evidence somewhere in those notes that will aid in a prosecution of the defendants. The stakes for Gretchen Voss are considerable. As she set out in her second affidavit submitted to the court with our motion for reconsideration, her effectiveness as an investigative reporter depends upon her having the ability to use the tools of the journalism trade, and among them is the opportunity to reliably assure her sources that certain information they provide to the reporter will be off the record. The precedential stakes are high as well, because the Commonwealth is essentially asking the court to give no weight whatsoever to the off-the-record nature of the notes. And that is what renders a journalist's promise of confidentiality illusory. Off the record is a phrase you hear in virtually every conversation between a reporter and the source. Frequently, it's an interjection in the course of a sentence. This is off the record. The kind of lubricant that allows a source to have a free and full exchange with the reporter without having to guard every word they speak. And receiving information off the record is often a technique by a reporter to establish trust and rapport with the source. That source might be a whistleblower, might be a frightened migrant, or might, like Reed, be a criminal suspect. On page 2 of our motion for reconsideration, we quote from Primer on Journalism that says, off-the-record interviews, quote, are essential in building trust between journalists and their sources, allowing for candid discussions that can provide context or background without the risk of public disclosure. The result, it says, is to enhance the depth of the reporting and provide leads for other sources. In Ms. Voss's case, she states in her second affidavit, which we filed with motion for reconsideration, at paragraph 11, she says, obtaining information from sources off the record is a normal and critical part of my work. Like most investigative reporters, I frequently agree with sources, including named sources, to keep certain of their statements or interviews off the record, not to be published anywhere. Keeping my word on this is critical to maintaining credibility and trust, and thus maintain source relationships while not interfering with the flow of important information to the public. The court's December 5 order forces Gretchen Voss to choose between either keeping her word to her source and thereby violating the court's command, or else obeying the court's order and establishing herself as a reporter whose word cannot be trusted. It's an unnecessary choice to present to her, at least on the facts of this case. The court shouldn't insist on publication of the off-the-record notes because the Commonwealth has failed to meet its burden under Rule 17 to show that mandated production of the records on the facts of this case would not be unreasonable or oppressive. And also because requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice for this criminal defendant. Now, I keep saying on these facts, because it's very clear that the inquiry is a fact-sensitive one. The First Circuit wrote in the Bruno and Stillman case that under Massachusetts law, the task is one that demands sensitivity, invites flexibility, and defies formula. While obviously the discretion of the trial judge has wide scope, it is a discretion informed by an awareness of First Amendment values and the precedential effect which decision in any one case would be likely to have. And in Re Cusimano in 1998, the First Circuit said, that was a case like this one, where that involved a demand for confidential information from an identified source. The same court reinforced the fact-specific nature of the inquiry. In Cusimano, they said, when a subpoena seeks divulgement of confidential information compiled by a journalist in anticipation of publication, courts must apply a balancing test. This test contemplates consideration of a myriad of factors, often uniquely drawn out of the factual circumstances of the particular case. Now, as I noted in the December 5 order, the court drew no distinction between the on-the-record and off-the-record interviews. When it applied the Massachusetts balancing test for mandating production of reporters' notes, texts, and audio texts, audio recordings, it did not treat this confidentiality promise as a factor in the equation. That, we submit, it was critical oversight, because whether you call it a privilege or not under Massachusetts law, Massachusetts does recognize that there is some degree of deference to be given to a promise of confidentiality. In Bruno and Stillman, the court said courts faced with enforcing requests for the discovery of materials, note it says materials, not source identities, and courts faced with enforcing requests for the discovery of materials used in the preparation of journalistic reports should be aware of the possibility that the unlimited or unthinking allowance of such requests would impinge upon First Amendment rights. In determining what, if any, limits should accordingly be placed upon the granting of such requests, courts must balance the potential harm to the free flow of information that might result against the asserted need for the requested information. So, what are the factors that the court should look at when conducting an analysis under Rule 17 and under the balancing test? Taking Rule 17 first, set out in the LaRouche case, they cite the Nixon case, where the Supreme Court ruled that in order to require production prior to trial, the moving party has to show, number one, that the documents are evidentiary and relevant, number two, that they're not otherwise procurable reasonably in advance of trial by the exercise of due diligence, number three, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And number 4, that the application is made in good faith and, critically, is not intended as a general fishing expedition. In short, the court was explaining that the special prosecutor in Nixon was required to clear 3 hurdles: relevancy, admissibility, and specificity. And the court held in Nixon that there was a sufficient likelihood that the tapes contained conversations relevant to the offenses charged, and sufficient preliminary showing that the subpoenaed tapes contained admissible evidence. In this case, however, there's been no showing that the handwritten notes contain information relevant to the offenses charged, and no showing that the handwritten notes contain admissible evidence. When you apply it to the facts of this case, there is uncertain relevancy of the information in the off-the-record notes. Not seeing them, it's hard to know whether they're relevant or not. But there's no specificity whatsoever in the form of a preliminary showing by the Commonwealth that the notes contain admissible evidence. Compare that to the materials the court ordered disclosed. The court found that there were indications in the redacted audio tapes that when unredacted, the tapes would contain relevant and admissible evidence. That's on page 5 of the court's order, which says the Rule 17 standard is satisfied, not only based on the tape. But there's no examination whatsoever of whether the interview notes would be anything more than a fishing expedition. To the contrary, the fact that nothing from that interview that resulted in the handwritten notes, nothing from that interview was used in the story. And that would suggest that the interview did not contain significant relevant information. As to the balancing test and the First Amendment interests, here too, the December 5 order ignores the on-the-record, off-the-record distinction. That distinction matters. Confidential information has extra protection because, as stated in LaRouche, disclosure of such confidential material would clearly jeopardize the ability of journalists and the media to gather information, and therefore would have a chilling effect on speech. The court in LaRouche identified First Amendment interests that militate against disclosure of confidential information. One was the threat of judicial intrusion into the news-gathering process. Another was the disadvantage of a journalist appearing to be a research tool for the government. Number 3 was the resulting disincentive to keep outtakes, or in our case, keep notes. And number 4, the burden on journalists' time and records and resources in responding to subpoenas. And if you look, Your Honor, at the affidavit of Chris Vogel that was submitted with our original opposition, he talks about each of those factors in his affidavit from paragraphs 13 through 18. He says he worries that compelled disclosure may lead to a public perception that Mrs. Voss is taking sides in this case or is acting as an investigative arm for the judiciary. Trust in the news media is already fragile because reporters compile information for a living. They will always be attractive targets of discovery for one side or the other. The unrestrained use of subpoenas to compel testimony or documents from reporters will create or reinforce the impression that objective journalists are working as agents of the government or the defense. The Fourth Estate could only serve its role as a pillar of democracy if it has the public's trust. Second concern that editor Chris Vogel pointed out in his affidavit was that another risk of compelled disclosure is that if it becomes easy or routine to subpoena journalists to hand over their interview notes, the legal and administrative costs of battling or complying will chip away at the precarious resources of much of the media. A third factor that
he's monotone
concerning him was that easy allowance of media subpoenas also risks leading to a decline in investigative journalism altogether. This is the most expensive kind of journalism. Reporting, writing, editing, and fact-checking investigative pieces take significant time and resources. Magazines like Boston Magazine will not be able to risk becoming enmeshed in situations such as this one, with the result that they shy away from controversial topics and the flow of vigorous reporting will suffer. We'll feel we have no choice but to select tamer, less controversial topics for our coverage. Another concern expressed by Editor Vogel is that reporters will be incentivized to destroy notes and interview tapes after a story is published, and that could harm the news outlet that it later needs to follow up on that piece. A fifth consequence is that reporters may tend to be circumspect in the way they gather information, in the way they conduct their interviews, and not be so vigorous in their questioning of sources and their documenting of interview notes, aware as they will be that their work may become the subject of public and judicial oversight. And finally, one factor that separates this case from many other cases out there is that Gretchen Voss has been the subject of invasive vitriol simply for writing about this controversial and very public matter. Public disclosure of her interview notes in this case risks putting her again in the limelight. Now, the court mentioned in its ruling that it appeared that she was no longer in fear of harassment because she had attended every day of the trial. I would submit that that shows that she was dedicated to covering the trial, come what may. She tells me she has, in the recent past, gotten more pushback on social media, including the fact that one commenter on Facebook, who I won't name, posted her personal telephone number for everyone. And the commenter to that post suggested I'll call her right away. And she's received several strange phone calls since that time. Because of the disproportionate harm to First Amendment and Article 16 interests caused by production of the confidential interview notes, we ask this court to consider its December 5 ruling and deny that part of the Commonwealth's motion that seeks those notes.
All right. Thank you very much.
Thank you, Your Honor.
I do have one point to make to you, Mr. Bertsche. In the amicus brief, or the memo that was filed this morning, I just want to be clear that I am not looking for Ms. Voss's own interpretations as well as her likely impressions and thoughts about the interview and overall story to be provided. But it makes sense to me, and I'm going to hear from the Commonwealth, and if you want to respond first, that any information that reflects or relates to conversations with the defendant must be turned over.
I'm not sure what the question is.
So I'm not looking, the amicus brief and your argument suggests that if I order these notes to be provided, and just to be clear, I do appreciate that they were provided to me to review in camera. So I can see a distinction between what I'm being told that generally all notes reflect the author's interpretations as well as her likely impressions and thoughts about the interview and overall story. That's not what I'm considering releasing. But I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over. So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. It's the communication between the defendant that's critical here. So I'm going to give you the opportunity to propose redactions to me. I have the notes, and you can propose redactions to things that are not reflective of communication with the defendant, observations, things of that nature.
Well, Brennan, there's nothing in the interview notes that is reflected in the story except architectural details, that there is a rosary on the bureau, or the wall is blue, or whatever it might be. And I went through the notes with this question in mind. Can you separate the impressions and integrity of the thoughts of the writer from the statements of the interviewee? And I don't think they're distinguishable. I think they're all melded together in one. And frankly, it's her selection of questions that she asks Ms. Reed that gives an eye hole into what her thoughts are about the case. She shouldn't have to produce that work product. And the Commonwealth hasn't shown that there's any more relevancy to these conversations with Gretchen Voss than there would be with any other conversation that Ms. Reed had with anyone else. There's no reason for the Commonwealth to be going after Gretchen Voss as a report for this, other than the fact that she's a reporter and she's done the investigative work already, that presumably the Commonwealth has already done.
Okay.
Thank you.
Thank you. Commonwealth?
Your Honor, I'll simply say we defer to the court's judgment and whatever limitations the court imposes. I have no further argument.
Okay. All right. So I'll take this under advisement. Thank you. All right. So paper 442.
Okay, so real quick, I'll pause it and then I'll catch up at 1.25 as they're like yapping. Okay, so real quick, this is the whole thing with the Gretchen Voss thing. She wrote that, I put the link in the comments or in the chat. She wrote that Boston Magazine article. They went through all of this last year, if you'll remember. And they said last year they were protecting all of her stuff. The ruling was made that it was, which Boston Magazine even did like a big article after that, you know, this was like a big win for free press in Massachusetts because they didn't have to turn over the confidential notes. The reason that this is such a big deal is because there's no shield law in Massachusetts. Massachusetts is only like one of, what, like maybe 10, less than 10 states that doesn't have a shield law for journalists. So Boston Magazine said that they would, you know, turn over the notes and all of the stuff for the on the record stuff, all of the you know, everything that was on the record. When they did the rest of it, they did redacted versions. Now Brennan wants everything he wants all of the redactions removed, and so the judge has now changed what her ruling was previously and has now ordered for all of this stuff. The reason that this is such a big deal is because, you know, they argued this whole point last year that there's, you know, the public relies on journalists to, you know, provide information. And if you are forcing her to turn over her notes and her, you know, off the record things, it kind of cuts her legs out from under her as far as being a journalist goes, because now, like he said a little while ago, now, you know, she's forcing Voss to either comply with the court and lose her journalistic integrity, you know, and be considered not a safe source, or, you know, go against the court, and that's, you know, hard for her. And also the argument about how, well, she's, you know, she was experiencing vitriol, but now she's not scared anymore because she showed up in court. That's a bullshit argument. Okay, because if that was the argument, then, okay, Jen McCabe showed up on for closings, right, and set right there. So like, you can't say that one person who has experienced harassment or vitriol online is not scared anymore because they showed up to court if you're not going to use the same argument for somebody else. So that's really that argument rubbed me the wrong way. But anyway, so now they're wanting the judge to revisit that ruling, and the judge is saying, I'll give you an opportunity to, redact different things or whatever. And he said that he can't distinguish between the things that are just her personal views on it and then things that were actually said. So, but the judge has already reviewed the off-the-record notes in private. So now she's going to take it into consideration, and we'll see how it goes. All right, let me put it on 1.25, and we'll catch up real quick.
This is the Commonwealth's motion for reciprocal discovery pertaining to employees of ARCCA. And I know from when we were last in court,
Crash Daddies
was perhaps having conversations with the federal people to see if you could get anywhere with this. Is there anything I need to know in that regard? And if we need to do it at sidebar, we can do it at sidebar.
I don't think there's a need, Your Honor.
Okay.
Although it's not incumbent on the Commonwealth to pursue Rule 14 discovery of a party that's going to proffer an expert, Commonwealth made best efforts anyways. I filed a TUI letter, and I was unexpectedly not disappointed when I received a response last night. It's insufficient, it's inadequate, so the issue of pursuing Rule 14 discovery with the proponent of the expert, that being the defense in this case, is something that is a matter we're going to have to address.
Okay.
I did speak to the defense this morning. Since the TUI letter came last night, they have, I don't want to speak for them, but have asked if we would consider some time so they can respond. I am content if it gets deferred until the next date, but it is an argument that needs to be made.
Okay, who's arguing now for the defendant?
Good morning, Your Honor.
Morning.
I agree with Mr. Brennan's recitation of our conversation this morning. If it pleases the court, we did get that TUI letter. I was copied in on that letter late last night. Reviewed it last night. I think that it would be incumbent for me to at least analyze that letter in a little bit more detail and utilize that letter in my response to the Rule 14 argument. So if we can have another date.
Sure. Well, we have next week, Thursday and Friday scheduled. So we'll do this next week and come up with proposals on how we can certainly not violate anything that the federal court has said we can't do, but ways that we can go about it.
We'll be mindful.
All right. So if you can work on that, I'd appreciate that.
Sure.
So I will take the lead from the two of you on that.
Thank you.
Okay.
That's
good.
good.
So this brings us to
That's good.
the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. So I have received a great deal of pleadings on this. So the Commonwealth's motion, and there was a affidavit attached, a report attached from Mr. Whiffen. The defense has filed an opposition, an affidavit from Mr. Green, and then another affidavit from Mr. Green that doesn't, they're two separate affidavits. And the affidavits are clearly different in substance, so I'm a little, I don't know what you want me to think about that, but why don't we hear the Commonwealth on its motion first?
Here we go.
May it please the court, we filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of how long to die in the cold at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry. In this case, I propose on behalf of the Commonwealth is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Green should testify and answer questions about his affidavit and his opinions that he would like to subject the jury to. In fairness, the government would call an expert as well. This case, as the court proposed, potentially scheduled for next week. Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available later in the month as a witness. My suggestion is there should be 2 witnesses, Mr. Green and 1 witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science, and methodology. And Mr. Green I suspect, should be in a position to explain his ultimate opinions because what we see in his affidavit is an absence of methodology. Mr. Green has filed 2 affidavits in this case. They are very similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits, when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a professional knows what they do for a profession.
Oh, goodness gracious.
Simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9. He talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit supports that thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy, insinuations and surmise and conjecture and claims that have no factual basis. But there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data, evaluation, or validation. Similarly, when we look at his affidavit, it is replete with accusations suggesting, but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened. But when we look through his entire affidavit, we don't see any attachment of raw data, but we don't see an updated report. We don't see any viable information that in any way supports his speculative accusations. And so the defense, without having an opportunity for Mr. Green prior to trial, stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common viewing the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government is going to take to this case. If Mr. Green is going to testify, he should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used. The defense wants to propose that there's some type of race that Mr. Green looked at or used more tools than a Commonwealth expert. The tool is simply software. A good analogy is that of an X-ray. Anybody can take an X-ray, but it takes an expert then to interpret the X-ray, to interpret the data. In this case, Mr. Green, in his affidavit, proposes that because he used a number of tools, because he has a number of X-rays, that somehow there's significance to it. But what it lacks is a forensic analysis of that information. And it is clear in his affidavit that it lacks that. He cites 2 opinions. His first opinion is based on Sunbright processing and Axiom processing. I'm not going to go through all the little details that we dispute or go through a technical assault on each point, although that the overall idea of this evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is stepped aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support in Cellbrite he relies on to say that this artifact, where this search is stored, is appropriate. And he remains standing on that foundation as why somehow there is some validation that this search occurred at 227. But then when he learns that Cellbrite, after actually doing analysis and study and updates and engaged in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason, and I'm sure the court has heard this before. Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance to Cellbrite, but then when they told me what I didn't like, I can ignore that part. He then defers to Axiom.
Okay, it goes the same way, buddy.
Axiom,
it goes both ways.
The government, the defense touts is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data.
Okay, real quick. Do we not see how he's like you can use that same argument against what you're saying? You're saying that Jesus, give me strength. He's saying that he's saying that Green is saying like, oh well, he was relying on, you know, Cellbrite until they didn't give him what he wanted to hear, and now he's like, oh, it's not reliable. Bro, you're doing the same thing. You're the one who's like, oh yeah, Cellbrite's reliable. Oh, but that showed the 227 search, so that's no longer reliable. This other version is, but not that. It's the same thing. It's the same thing.
Data. And that gets back to the X-ray analogy. He is viewing data from many different programs that say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that the Axiom user manual describing the artifact as follows, that the artifact is in Safari suspended state tabs, and then has the last interaction date time, and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual, they don't introduce the manual, and he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes, in their artifact reference guide for the description of Safari suspended state tabs, which he's referring to, and this is the death knell, really, for the analogy that the defense tries to make. The Safari suspended tabs contains the current state of each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results from the artifact may contain an earlier date and time compared to the results in the Safari history artifact if multiple devices on one iCloud account. And so, by Axiom itself, it makes clear that an artifact in a tab can reflect a time that is much earlier than the actual search. And this has been presented to the court, and we've provided the trial transcripts of Ms. Hyde and Mr. Whiffen. When a tab is open, many tabs can be open, it is open at a particular time. And if that tab is reused, the original time will imprint. And so, certainly Mr. Green knows of the Commonwealth's argument. He knows of the opinions by Mr. Whiffen and Ms. Hyde, because he takes shots at them or makes mention of them in his report, and yet he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of a side. When you look at their reports, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear. Now, there are two opinions that are proposed pursuant to this affidavit. The first is the claim that how long to die in cold was somehow inputted at 227. The only effort that appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffen and Mr. Green. But a simple understanding, wall file can contain information as a repository. And the description or misunderstanding by Mr. Green of the wall file is clear in his affidavit. In fact, he implies that there were 3 searches in his affidavit, number 16.
I don't know why he keeps doing that.
Phone that there were 2. Surprised at his second opinion is an attempt really just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because, number one, it doesn't have any resonance.
Well, let me change feeds. That's driving me crazy.
Somewhere, somehow. Not an uncommon. The claim, or the opinion number two, the defense would like the jury to hear, is that somebody somehow, whether it was a person, presumably the witness in this case, or the police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness, an expert, is going to promote in an affidavit a claim with no factual basis, we should not trust, without vetting that witness, that their other claims have any merit or value. In opinion number two, this expert, so-called expert, takes the liberty to say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated, then rehashed after manipulation with the PDF being modified. Wow. It's an extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It is because the claims he makes in opinion number one are so scientifically and forensically unsound.
That's bullshit. I'm so...
Is a tactic.
Let me mute myself.
The issue. And think about the import of this baseless claim by Mr. Green. It is suggesting that a witness with no other evidence whatsoever was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when you don't have any facts. Now, how could one cause manipulation? There is scientific ways that can be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case. Because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact in data and science. Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police. When you look at the data in the phone, the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Green ignores. And so not being able to prove user manipulation, because it didn't happen, he turns to police manipulation. And he says that there can be a problem where the hashes don't match, but the problem is the hashes do. They match. He complains that he did not receive the PDF when he received the download. And because there was a production at different times, he then sprints out to a different universe and suggests that somehow it must be because there's manipulation. And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, the gray key file, and the phone and determine whether manipulation occurred. There's a program called XMP and another one called Magic. The problem, most expert witnesses went through that process. No manipulation. But Mr. Green doesn't even go through the process to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just posit hand grenades throughout the case and let them resonate wherever they fall. In an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all.
Okay, hold on, because this is a lot. I want to pause for a second. He's once again making an argument that he's not applying to his own argument, because he's saying that there was no deletion or manipulation by the police or by the witness. And if there was, there would be proof. He used the X-ray thing, saying that you can get an X-ray, but you have to be able to interpret it. So if you're giving the argument that these experts are coming in to interpret the data, then you can't make that argument and then turn around and say, Well, there's no proof, because if that's his interpretation, then he's an expert. He's been qualified as an expert, and he gave his reasoning why he interpreted it that way. So you can't say, oh, you have to have proof if you're also saying it's up to the expert to interpret the data. You can't have... Brennan annoys the bejesus out of me.
I could go through each one of them. I could give a difference of opinion. I could show that Mr. Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify, explain to the court why he did not engage in methodology and how he has come to these extraordinarily baseless, inaccurate, and prejudicial claims.
Prejudicial.
Commonwealth has to, the court rather, has to look at Lanigan and whether or not a hearing is appropriate in this case. When we look at the different non-binding factors of Lanigan, we look at number one, whether it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, the expertise. And the defense complains in the motion the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. So this is the way to address the methodology. Number two, the opinions have been or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffin's report directly contradict the assertions, the unsupported assertions of Mr. Green. There is no testing that his opinions have been subjected to. There is no peer review. There is no other alternative support for his opinions. They're just broad, baseless claims. Number three, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Green's interpretations, it hasn't been subjected to anything. In fact, it changes. Has an unacceptably high known potential rate of error. Well, if we see and read Ms. Hyde, and it's just a high level of error, it's gross error, it's total error, it's wrong, and is governed by recognized standards. Well, if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test, things that Mr. Green didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not follow Axiom or the guidance that they give him. He sidesteps both of them to give the opinion he wanted to advocate for the defense. At every turn, the positions of Mr. Green are not only unsupported, they're unverified. And so what arises from this subterfuge is that Mr. Green is really just a vessel, or an attempted vessel, for the defense, third-party culprit defense. It is not lost on me, I'm not unmindful of the date on the phone being a search Holland Diane call that occurred after 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions around that time about Mr. O'Keefe and how long he could survive in the boat. Under the extraordinary broadness of circumstances in the depth of the amount of witnesses and information in this case, it is hard to think that that just happened by happenstance. That there is a inquiry, something forming in the mind of the accused, is then shared with the witness, Ms. McCabe, and in response, she makes the search, which is entirely supported by all the credible forensic evidence. If Mr. Green is going to be a witness in front of the jury, in light of the fact that he has no methodology and he's wrong on the science, in addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense, he should have to stand behind those claims under oath. And so I'm asking for a Lanigan hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right, thank you. Mr. Alessi?
Oh, I'm so glad Alessi's arguing this. I have so much to say. I'm going to put a lot of my stuff in the podcast episode to go over all this, but we'll talk about it in a minute too.
May it please the court. Mr. Green is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search house long to die in the cold that occurred at 2:27:40 a.m. on January 29, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously, and presided over that trial. Your Honor did not issue, after his testimony, any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution, after his testimony, stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established, again, without objection. And
But they are being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detail than what happened in the first trial. In Mr. Brennan's argument, he did not make one argument about Mr. Green's qualifications. Zero. So I'm assuming, because there's nothing in their motion that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to 5 other areas of data forensics, and there's just this challenge to one aspect of his whole testimony and opinions. I have provided Your Honor with 2 exhibits demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs, and I would like to, Your Honor, use those in a moment. The Commonwealth, in its oral argument, said 10 times just now that there's no methodology and that Mr. Green does not articulate a methodology. That is incredible to me because the opposition and Mr. Green's affidavit, in fact, are replete with the methodology. And here is the key, Your Honor. While Mr. Brennan challenges the methodology, none of his witnesses, neither Mr. Whiffen nor Ms. Hyde, challenge the methodology. As a matter of fact, in their 2 reports, neither of them even describe Mr. Green's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to now. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, Jen McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Green's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step 1, you receive, and this is to answer the question about what is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step 1, receive a full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step one in the methodology that everybody agrees to, everybody agrees that occurred.
I love how he walks through
Number
things.
two, verify hash signature value of image file of data received. This is very important because hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint, that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The Commonwealth just said that Mr. Green has hurled several accusations without a basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Green did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Ms. McCabe, he used Celebrite UFED, a tool of Celebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens in every case, without exception, is that the law enforcement sends the raw image, original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it, in this case, SHA-256. What it is it's a stamp of reliability that says, as soon as we got this data, we immediately processed it the proper way and put a hash signature so that there can be no contest. What the Commonwealth fails to tell the court, Your Honor, is...
Stop doing that.
And that leads any proper data forensic investigator to question the integrity of the data. If you turn to, Your Honor, Mr. Whiffen's very long December 2024 report, which is Exhibit 1 to the Commonwealth's motion on page 3, and I'm going to read it verbatim. This value is talking.
Why is it doing that?
Here's the key point. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication. That's all a fancy camouflage way of saying, Mr. Whiffen saying, I can't validate this hash value because of the way Trooper Garino processed it. Do it, Mr. Garino, Trooper Garino, the right way when he got it. And why is this of concern? Add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Garino used the Celebrite UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data, the full. So Mr. Green had to ask for the data. Then what happens, misstep number 2, Trooper Garino only provides a PDF of the hash value. He used gray key, which was a mistake, because gray key, you can't get the original hash value. Mr. Green had to go back a second time and say, no, we don't want just a PDF. We want the full extraction. Finally, after the second time, the defense got the full extraction. And that's when we discovered that the validation was improper. It's not Mr. Green that is coming up out of thin air with these issues. This is the job of a data forensic person, and the first principle is to see whether the data is valid. So not only does Mr. Green justify in his affidavit why there's a big concern over this, Mr. Whiffen concedes it on page 3 of his report. That starts, and I'm going to get to it, all the concerns now about the data and deletions. But that's the foundation for it, and it wasn't caused by the defense. It was caused by Trooper Garino, who didn't do this properly. And with regard to the methodology, I want to go back to Exhibit 1. So, and importantly, Your Honor, 1 through 4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffen, Ms. Hyde, and Mr. Green all agree on 1 through 4. They all agree that this is the methodology. Number 3, once you get the image of the file, each examiner saves the image to their lab storage system. Some use computer servers, some cloud storage. And 4, the methodology, you then process the data with appropriate tools. Nobody disputes that Cellebrite Physical Analyzer and Magnet Forensic Axiom are 2 of the many tools that are available to use. There's a dotted line that I've put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5. And 1 through 4 is usually all one needs to do as a data forensic examiner. But Mr. Green went on to do more. Number 5, further processing of data as warranted, and he explains why it's warranted here, with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then he didn't use iLeap, Ms. Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Green state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. So, interestingly, it is Mr. Whiffen who provided the most lengthy report in this motion. Mr. Whiffen only used 2 forensic tools. He only used Cellebrite Physical Analyzer and his own software, ArtX. That's it. What I'd like to, Your Honor, is ask if I could, please, if you could turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses.
He's really good.
And I just want to make sure Your Honor has that.
If I ever end up on Snapped, I'm getting him as my attorney.
Okay.
So I prepared this demonstrative exhibit to show the tools that all parties used. And the purpose of this is to show how closely Mr. Green and Ms. Hyde match up with the tools used, and how insufficient Mr. Whiffen and Mr. Garino are. So, if you look at the left-hand column on Mr. Green, and I color-coded it to try to make it easier, you see 7 tools used by Mr. Green. You see 6 tools used by Ms. Hyde in May of 2023. Many of her tools exact same as Mr. Green. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Celebrite Physical Analyzer. And then Mr. Garino, Trooper Garino, used 2 tools. But here's what's really important and I think remarkable that springs from this chart. Mr. Green did more, had a more encompassing and comprehensive review than any of the witnesses here. And back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that. The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue. And Mr. Green makes that very, very clear in his affidavit that the difference is in opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Dalbert Lanigan hearing. Opinions are not. Here's what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1-10, starting on lines 14, the question. And what, if anything, did you find with regard to the web history artifacts? Answer, and this is Mr. Whiffen. So the 2/27/40 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. But the interesting thing was why the timestamp said 2/27/40. And I did some testing on this and discovered the reason why 2/27/40 was actually listed in the database. Even though that's not the time, here's the key. In my opinion, that the search was conducted. So Mr. Green's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used, plus more, Mr. Green's opinion is, to a reasonable degree of scientific certainty, that that search and that record that everybody saw at the time of trial, at 2/27/40, House Long to Die in the Cold, Mr. Green says it means what it says. The search occurred at that time. Now, the Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it, it's in there. Ms. Hyde said, I see it, it's not only in there in Celebrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224. In fairness to trying to get the best decision for Your Honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 2/27/40. That's the opinion that's disputed. So in fairness to the issue and accuracy, those witnesses diverted at the end as to whether what that timestamp showed, 2:27:40 a.m., did the search really occur then, or as the Commonwealth said, did it occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact, and that Mr. Green doesn't have any fact. Well, Mr. Green's got a lot of facts, and he also, of course, has an opinion. So what we have from these two demonstrative exhibits, Your Honor, is a statement of the methodology in Exhibit 1 that every witness agrees to. Not only is it Mr. Green put a methodology, but we prove up in the opposition that there's no dispute. What's interesting, Your Honor, and I think quite remarkable, is that neither Mr. Whiffen in his 40-plus page report of December 24, nor Ms. Hyde in her December 24 4-page report, neither one of them say Mr. Green's doesn't have a methodology. They don't say we dispute his methodology. It's the Commonwealth's attorneys that are making that dispute. And that is not appropriate. It's got to be your expert. And I think there's a reason why the experts of the Commonwealth are not talking about methodologies or saying there's a dispute, because it's objectively verifiable that there's not a dispute over the methodology. What is also important is what has happened since the trial. And what I want to do is give a baseline of the trial, because I think it underscores the two issues that Your Honor have in front of you: qualifications and methodology. And the qualifications, all I'm going to say about that is Mr. Green has 25 years of experience in computer forensics, and he has 18 years in digital forensics. And the 18 is only because digital forensics became a thing 18 years old. There can be no dispute, and I think that's why the Commonwealth didn't really say anything about it, is because if you lay down Mr. Green's experience next to Mr. Whiffen, Mr. Green testified 23 times as a qualified digital forensic expert in 7 different states. Mr. Whiffen, he's testified in 2 states, one of which was here, and he does not have anywhere near the years of experience. Here's another very important point: certifications. Mr. Green lists 3 certifications. He lists an enormous amount of constant updating, and I just want to state a point about digital forensic experts. They're not like medical doctors where you see people with PhDs, etc. These are folks that keep updated because the computers change so much, so that's why you see such a great listing of Mr. Green in terms of his training and certificates, etc. However, if you compare Mr. Whiffen's qualifications to Mr. Green, and I'm again going to use Mr. Whiffen's own words with regard to his qualifications on his June 7th, this is again Exhibit 2 to our opposition, his June 17th trial testimony, page 1-6. Question, and this is a question from Mr. Lau. Now, with regard to your education in this area, what, if any, certifications do you have? Answer, no specific certifications. I've done the Celebrite coursework since joining Celebrite, but other than the 3-week course in Ottawa, and then again the 2-week course in Ottawa, those are police training things when he's a policeman. I don't have the SANS training or any of that kind of training certifications. Now, I am not here today to challenge Mr. Whiffen's qualifications. But how could it possibly be asserted that Mr. Green's not qualified if these are the qualifications of Mr. Whiffen? With regard to what has changed since the first trial, and I think this is incredibly important with regard to the methodology inquiry of Your Honor. I went through on Exhibit 1 the methodology that everybody agrees to, but the court doesn't have to take my word for it on this demonstrative exhibit because Ms. Hyde gives the best explication of the methodology that Mr. Green used because she used the same one before trial and at trial, but she's now narrowed it for purposes of a report, and I'm going to state and show exactly how. So Exhibit 4 to our opposition, Your Honor, is the May 2023 Digital Forensics Analysis Report of Jessica Hyde. And in that report, on page 3, she talks about, under forensic analysis, that she used, it's the exact same methodology.
What are you, I thought you said Exhibit 4. Exhibit 4 is a transcript. It's a transcript of Ms. Hyde, but it's not a report.
Okay, my fault, we have different numbering, but I'll go to the transcript. I'm going to go to the transcript with regard to it. So
I'm happy to look at the report if that's what you're referencing.
I'm
Where
going to
do I
go to the
find
report
it?
next, but if Your Honor's already at the, I can do it either way. If Your Honor is at the transcript, I'll go to the transcript right now. This is the June 14th transcript, Your Honor, of Jessica Hyde?
Yes.
Thank you. So, we're just, and please keep in mind that in Mr. Hyde's 2024 report, that Mr. Whiffin's report that is now before you, Mr. Whiffin only used, in his analysis now, Celebrite Physical Analyzer and ARCCA, his own tool. He only used 2 tools. Ms. Hyde, in her 2024 report, which I will get to, is now down to just using 1 tool, Celebrite Physical Analyzer, because she states that's the only one I was asked to look at. So the Commonwealth went and narrowed the request of Ms. Hyde to just Celebrite Physical Analyzer. And what is going on here? It's very obvious. The Commonwealth is ignoring, in its 2024 December reports, all the other tools. Even though those tools show this timestamp of 2/27/40 still, at that time, they now just ignore it and go to the Celebrite Physical Analyzer. That it's undisputed that Celebrite went back and changed it in the middle of the first trial with regard to one physical analyzer program. And then after the trial, the other physical analyzer program, they went and changed that and took it off. But in contrast, Axiom, that Ms. Hyde used before, still shows the timestamp. It's undisputed that that's the case. And it's undisputed, because they don't contest it, that Mr. Green went and looked at it in Belkasoft, Sanderson. He did a manual, he did a low-level analysis, and in every one of those tools, the timestamp still occurs. So now back to the transcript. Your Honor,
that's a huge deal.
You know, the question of, and this is, again, a significant point, is it better to use more tools? It's common sense. That's what Mr. Green says. That's what Ms. Hyde did the first time, but now all of a sudden she's down to just 1 tool that unilaterally removed the timestamp. So here is the page of the transcript of what Ms. Hyde had to say. Page 1-13, Your Honor.
Okay.
Line 4. Question, again, of Mr. Lally. Now, with reference to the tools that you use that you just went through, are those fairly common tools? Are those tools that are commonly used within your industry? Answer, yes. And what are those tools that she talks about above? Starts on page 1-2. Celebrite Physical Analyzer, Magnet Axiom, Artex, iLeap, and I later used Sanderson Forensic SQLite. Those are 4 of the tools that Mr. Green used, and he used more. So her answer is, now with reference to the tools, are those tools that are commonly used within your industry? Answer, yes. They are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. It gets better for the defense. Next
But wait,
question,
there's
line
more.
15. So different forensic tools, question. And why were you using the different tools? So different forensic tools have different capabilities and look at data a little bit differently. Skip down. Commercial forensic tools that they can only support so many applications, so they each work and support different bits of data. Here's the key point, line 22. This is Ms. Hyde's words, under oath. So it's important to use multiple tools so you can see the results from different different data sets, and be able to compare those results and enhance those with manual analysis. Next page. Question. And with respect to, and this will be the last question and answer, and with respect to using those sort of different variety of tools, Celebrite, to Axioms, to Artex, etc., is that something you typically do as far as your normal process of documenting a forensic analysis? Answer. Yeah, that is very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent. And down below, he asked, can you explain the interplay of these tools in analysis? And her answer is strikingly the same as Mr. Green in his affidavit and in our opposition. Her answer, the Sanderson's tool, which Mr. Green and Ms. Hyde used, but Mr. Whiffen didn't, is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Mr. Whiffen didn't use the Sanderson tool. So here we have...
That's a huge
Ms.
argument.
Hyde, and in her report of 5/23/2024, her first report, and I'm going to get to her report here, she basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the House Long to Die timestamp 22740 in every single tool that she used. Where she diverted from Mr. Green was her opinion as to whether that timestamp meant the search occurred at that time or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees in its opinion issue in that regard. So now let's come to where we are for this motion and what was submitted by the Commonwealth. And I want to first go to the report of Ms. Hyde now.
He's such a good attorney.
It's Exhibit 4 to the Commonwealth's motion. And it's entitled Digital Forensics Analysis Report. And there's been much said in the Commonwealth's argument this morning about allegations made by Mr. Green, which are all supported. Every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools. What does she do now in December of 2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Celebrite Physical Analyzer, and it's gone. The search is gone, right? And we know why it's gone, because Celebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Celebrite Physical Analyzer? We don't know the answer. All that is stated is a bald conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable, but we know it's gone. And Mr. Whiffen never says, even though it's gone in one, he doesn't even address the other 4 or 5 tools, where it still appears. It still appears. Now to Ms. Hyde. Disquietingly, on page 3, look at the request, please. The request was to understand changes made in newer versions of Cellebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely, House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then Cellebrite had deleted in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Cellebrite Physical Analyzer, version blah, 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 decoding engine, etc. Where is her analysis of Axiom that was in her May 2023 report? Where is her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there? So what she goes on to say is very interesting, but it's buried, and here's what it is on page 4. After she goes through and states what everybody knows is Cellebrite just went back and for some reason deleted it, she says under the chart, while manual analysis of the database still shows a 2:27:40 a.m. ET timestamp, the determination in prior analyses and from Cellebrite is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis, and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses in Cellebrite Physical Analyzer.
So are you telling me that we should have a hearing?
Your Honor, there's no need to have a hearing, and here's why. There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert, because experts, almost by definition on each side, disagree on the opinions. We don't need a hearing, Your Honor, because they agree on the methodology, they agree that more tools are better, they agree that the difference is at the very end of the analysis, which is the opinion. So in terms of the issues with regard to Mr. Green's report, which is my final point to get to, there's been so many mischaracterizations by the Commonwealth this morning of what Mr. Green did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to look at, to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean. And everybody here has the same data, right? Everyone's got the same data that they're using, so there's no dispute over that. The Commonwealth said that there's no factual basis for what Mr. Green did. There's a factual basis for everything, and it's undisputed. So everyone has the same data, and this I call the MB postulate. And the MB postulate is, why are people using different tools, etc.? Is because nobody has the source code for the Apple phones. So you use these tools to try to help interpret what these source codes mean. And it's an accepted methodology to do it. But the data, once it's produced, and we have an issue about what happened before it got produced, but in terms of the methodology that was applied here in the tools, there is no disagreement. So what, Your Honor, would an evidentiary hearing do? We're just going to come in and have witnesses talk about their difference of opinion? That's not what a Daubert is for. There's no basis for an evidentiary hearing because there's no dispute over the methodology. I've done a lot of Daubert hearings. I've never even gotten past a motion, let alone an evidentiary hearing, where the experts don't disagree on the methodology. So what is it that caused Mr. Green to raise questions? And again, I said data forensic examiners are just like the medical examiners. They don't look at just the body of the medical examiner. They look at circumstances surrounding it and all information. Well, that's what digital forensic examiners do, and that's what Mr. Green did. So there's great criticism of Mr. Green from doing what is proper for a digital forensic person, and it's a bit of a camouflage, respectfully, because the December 2024 reports of the Commonwealth now myopically go down to just one tool. So what did Mr. Green say that caused him to say, I think it strongly suggests that there's been manipulation here? He used the fact that there's no hash value for the data. That's conceded. And when there's an issue over hash value, every single digital forensic expert is going to raise concerns about the validity of the data. And Mr. Whiffen is one of them who did that. Secondly, what Mr. Green pointed out on the issue of was this search deleted, there were 4,056 searches on the phone of Ms. McCabe. 4,056. There was one deletion out of 4,056, and guess which one it was? House long to die in the cold. There are no odds that that can happen randomly, that one search out of 4,056 is deleted. So what does Mr. Green say? He says that strongly suggests one of two things. Either there was user interaction deletion, or there was post-imaging manipulation of the data. He doesn't accuse individuals. He says user interaction or post-imaging. That is the job of a digital forensic person, to point that out and say that raises concern. The fact that there's only one deletion of a search out of 4,056, I think it's malpractice if a digital forensic examiner doesn't point that out. Another key thing he points out is an anomaly. The Commonwealth said there was a tab number for Hockomock Sports, and that they said it was the same tab number for how long to search or how long to die in the cold. But Mr. Green points out that's incorrect. They had two different tab numbers. So that theory of the prosecution can't be right. So Mr. Green wasn't hurling accusations. He was doing what data forensic examiners do, is pointing out all these anomalies. These aren't things you normally see, and they're not explainable. Here's the last point I'll make, which there's also agreement. There's this deletion of this one search. Mr. Whiffen can't explain why. He says, well, maybe it was a spontaneous deletion. There's no such thing in data forensics as spontaneous, and he doesn't cite any. Maybe it's because the search didn't load. Maybe it's because there was bad connectivity at where this search occurred. Well, that's interesting because a harder thing to load, the image that came up with food, did load. So you got to have stronger connectivity to get an image that dense. So what Mr. Green simply points out is that doesn't make any sense either. That is the essence of Mr. Green's affidavit. And Your Honor, just to be clear, when we sent in the second affidavit of Mr. Green, we put in the cover, and Your Honor may not have gotten this, that it was to replace the first affidavit because there were some typos, etc., etc. So you'll see two dates of the affidavits, and it's the later date, and I'm going to give you the specific one that controls.
No, I have both.
Okay,
but
right, yeah.
The second one on the body of it does not say it's a supplemental or anything. If it was in the cover letter, that's what, they're both docketed, so they'll both remain
I was just
docketed.
going to say, we wanted to have them both there for whatever purpose Your Honor wanted, but there's been some question about why two, and it's a simple explanation, one supersedes the other. So, Your Honor, in terms of, and this will be the concluding part of my remarks, in terms of the allegation that Mr. Green relies upon technical support at Axiom, and he relies upon technical support of Axiom, and the statement that is just remarkable, that that's the basis for his expertise. Mr. Green makes very clear that he did his own analysis, he used the tools himself, but here's why he called Celebrite. At the time of trial, Celebrite had two versions of physical analyzer on the market at the same time. One physical analyzer 7 showed the 22740 timestamp. It showed it, and it showed it in a deleted state. But the recent one, the one that Celebrite updated 1 week before trial, didn't have it. So that was the Insights, spelled oddly, INSYETES. That didn't have it. So Mr. Green did what any good digital forensic person would do. He called up support and said, well, you know, what's going on here? You got one that shows it, you got one that doesn't. But he did what the NIST standards, the National Institute of Standards, and that's attached to Mr. Green's affidavit, says that good digital examiners use multiple tools, and when they have questions or they see anomalies, you call up the program people, you talk to their technical support. That's not someone inexperienced and relying upon them. That is the proper methodology. So Mr. Green did that to corroborate and get explanation for what he found. So in sum, Your Honor, here is what is before the court and what is
He's so good
for this motion. What is pertinent is the inquiry under Polk, which Your Honor cited in your decision on Dr. Russell. It comes down to, is Mr. Green qualified? There's not even a contest. Second, is his methodology reliable? And Your Honor, those are the only two subjects that are ever proper for a Daubert hearing. Why would we have what will be a very long hearing? Now Mr. Brennan suggests bringing in Mr. Whiffen. I've never heard of that happening in a Daubert hearing, where one party challenges the witness of the other, and then says, and oh, by the way, I want to bring in my witness to show. That never happens in Daubert. It's the person who...
I wouldn't say never.
Well, let me take that back. Good point. I won't say never. It is so unusual to have that happen under these circumstances. And this is the key, Your Honor. Why would we have a hearing about whether his methodology is proper and reliable if all of the witnesses agree what the methodology is? So, Your Honor, in conclusion, I would urge the court to deny the motion of the Commonwealth to exclude Mr. Green on one of 6 data forensic issues. He's going to be testifying, obviously, at this trial. And I would urge Your Honor to not have the evidentiary hearing, because Your Honor has before you everything Your Honor needs to perform the gatekeeping function. And again, it's almost all undisputed with exception of one thing, and that's the opinions of the expert, which is never proper. I will respectfully state that never is appropriate for a Daubert hearing. Thank you, Your Honor.
Okay. Any follow-up, Mr. Brennan?
I do.
Of course you do. He made some great arguments. We'll talk about it in a second.
A little bit of knowledge of forensic data analysis can be dangerous. So when you hear representations or arguments that Mr. Whiffin's opinion that there may have been a connectivity issue is undermined because there was a picture of food which is suggested through a application search, misunderstands the basic premise that that's a cache picture. And that is meant for the user of a phone, for the user experience. And so there is cached items that are available without connection that register and come up quicker from a different source while it's waiting for a search to be conducted. It's simple, it can be explained, it's science, it's data. So when you take a little bit of data and you twist it because you misunderstand it or you want to advocate, that is the danger, and that's why it's best left to experts. What the defense apparently is mistaken about is that using a number of tools does not substitute for methodology. You can use one tool, you can use 30 tools. They're all going to say on the timestamp that how long to die in the code occurred at 2:27 on that browser. That is the time that was opened. That window was opened at 2:27. But you can't just look at 8 different tools that are all going to say the timestamp is the same. You have to look into the data and into the databases, knowledge C, the history, and you have to determine what artifacts exist to show that occurred at that time. And when you do that in this process, it is clear that 2:27 search happened after 6 a.m. in the morning. And so that's what Mr. Green doesn't do. He doesn't engage in methodology at all. There's an agreed methodology. He doesn't use it. The defense points to Ms. Hyde's report, how it's narrow. It's narrow because it's an addition to her 2023 report. Mr. Green has not written a report. He has not provided data. He has not provided that he has used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls. And so you can't simply look at the timestamp and then give a reckless opinion not based on the methodology. We still haven't seen a report from Mr. Green. There is none. Because if he actually does the testing and takes a phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him. There is no hashtag concern. And when the defense raises issues, postures, ideas, we never hear what the problem is. What is the hashtag, Darren? Who manipulated it? And that is the MO. Blame anybody, don't articulate who. Be like a ghost, evasive as possible, and then when it gets knocked down, just posit a new theory. The government offers to bring in Jessica Hyde next week or in with him at another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to. So there is a real accuracy on the fallacies that Mr. Green promotes in this case. And so we're happy to do it. We welcome it.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your
Okay.
Honor. Thank you for the opportunity.
There's that
The
sigh.
Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth woman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing. Thank you, Your Honor.
All right. Well,
There are 4 exhibits that have been marked.
Thank you. So it sounds a lot like it may just be a disagreement in opinions, but for the Commonwealth, I will look more closely at your methodology arguments that were made today.
Good for you,
If I
Bev.
decide that we need a hearing, an evidentiary hearing, and that I cannot decide this motion based on everything before me, I will let you know no later than Monday. Okay? So we'll keep
Yes,
next
thank
week, and I'll let you know. All right. So
I mean, you can't really argue with it.
not that I would exclude something simply because it takes a lot of time, but we really need to make sure we keep this case on track for the April 1st trial. So I have a question for the Commonwealth on where we stand in discovery, and then we're going to talk a little bit about the motion to recover expert-related expenses.
Your Honor, we've been producing discovery as we've gone along to try to give the defense as much notice as we can. I had anticipated having discovery finished last week. We've sent over most of our discovery last night, or it's in the process of being turned over. There was one further report. We've retained Dr. Wilkes as a neurologist. I'm waiting for his report. He is away. And so my expectation is I can have that report by Wednesday.
Okay.
Further, there was a witness interview earlier in the week. I'll have that report as well. My Rule 14 commitments are ongoing. They are involved. Enormous amount of time over the months has been spent trying to satisfy that I can account for all the discovery and make sure the defense gets everything that I can as soon as I learn about it. We'll continue to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Okay. Does that include the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. There's something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday. That's all included.
All right,
The analysis is done. The accident reconstruction is done. Mr. Crosby, with expertise in bites and dog bites, his reports are in. Ms. Hyde and Mr. Whiffen have further reports that have been provided. Ms. Hyde has one more that's outstanding. We may have it. I expected it last night. I have not reviewed. And I think that accounts for. We've been through the entire amount of discovery that was prior. It has all been Bates numbered. It hadn't been before, and it's marked as previously provided. I've made a very, very thorough accounting analysis with help of all of the information that isn't in those Bates numbers, and provided everything that I've come across as soon as I come across it.
All right.
Continue to look through all of our materials. There was an issue regarding a phone that we hired a third party to look through the phone and produce all Rule 14 discovery. I mentioned that my position was that it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed by somebody else, so I did it myself. And so I've gone through the entire phone, every email, every page, thousands, and I've provided not only Rule 14, but a broader discovery pursuant to a protective order this morning to the defense, so they have anything that, from my perspective, from my experience, would be remotely important or interesting to them. Also, I've gone through, well beyond my obligation, emails of members of the District Attorney's Office, and that continues, and I have another production as well. I wouldn't call it Rule 14 because it's not necessarily statements of witnesses, but again, I've taken a very, very liberal and broad view of what I would potentially want if I was defending the case. And I've provided that again under seal today.
All right.
And so we do not have an official discovery order, but I'd like the defense to have their discovery to me 30 days after I complete mine, which will be next week.
Okay.
We filed, but I did not see on the docket, or we sent in, we did not file a motion for clarification, and Your Honor did not mention that. That's an important notice that we had sent in, because I am greatly respecting the April 1st trial date, and there's work to be done. And so I would like to address that motion to clarify when appropriate with the court.
Okay. I'll need some time to review this, obviously.
Yes, Your Honor.
Okay. All right. That's great. So the Commonwealth expects to be ready for trial April 1st?
Yes, we do.
Okay. All right. So now let's just take a look at a preview, if you will, of the defendant's motion to recover expert-related expenses from the Commonwealth. Okay. I see there's a written opposition that I just received. We're not going to hear this motion today because I didn't have the opposition, but one of the things that I'm hoping you can tell me before we hear this, all right, there are a couple of things. Let me just, in this motion, there's a footnote that references, so this motion from the Commonwealth was filed, from the defendant, was filed on January 23rd. So more than a week ago, and the motion, I believe, is a footnote that highlights a pending motion to dismiss. I need that motion to dismiss. We need to get this moving. When will that, well, I'd like that filed next week so we can hear it next week.
The reason that we haven't finalized it, the reason we haven't put the full contours on that motion is because we haven't received all the discovery. And I think it would be premature for us to figure out exactly what the parameters of our motion to dismiss are until we know exactly what the Commonwealth is putting in front of us in terms of a second trial. But as soon as we get that, we think that we have the grounds to bring that motion relatively quickly thereafter.
So you expect to have everything to the defendants by Wednesday?
I do, and really what's missing is a report from a neurologist, a witness interview that is really inconsequential, and Ms. Hyde has a report regarding a phone. That's all that's really left for discovery, so that's all I can say.
All right, so if you get it by Wednesday, we're here Thursday and Friday. I'd really like to see something by Friday. You've obviously been working on it, even if we end up having to do it in piecemeal.
We've been thinking about it, but we have not. I don't know what you mean by working on it. Yes, obviously we're working that direction, but Your Honor, there's no way for us to reasonably get that done by Friday. That's just, there's so many other things that we're dealing with, including hearings like this that keep coming up over and over and over. I'm not. The court knows we don't drag our feet. As soon as we get something, we act on it. I just can't promise that we could get it done by Friday. We are working on it, and we're not.
So
there's no strategy for us waiting. I promise you.
Be prepared to discuss it next Friday. I will be looking for it very shortly thereafter, and we will have a hearing on it very shortly.
Keep doing that.
To respond.
Understood.
So we need to come up with a scheduling order, or I've got a scheduling order that we need to discuss. But regarding this motion, what I need to know before I hear the motion on the expert-related expenses is what sort of protocol you all worked out. Maybe it's in the Commonwealth's opposition that I just saw. What sort of protocol was worked out? Who was notified? What the arrangements were? How this all was set into play, and why there was a violation?
I can certainly brief that for the court. We addressed it pretty significantly in our motion in terms of the conversations that were had, the expectations that we had, the protocol in terms of getting our expert out there from Arizona.
No, what the agreement was, right? People don't just show up for the other side's expert. I just need to know what the agreement was for your expert to view this on that date.
Most of this was reduced to email. I think it'd be
so
probably a little bit more accurate for me to just go back and file a supplemental brief.
Yeah, so I need all that information from such egregious conduct.
Sure. Okay. I'll submit that won't take very long, and I'll.
Because then we'll address this next week.
Okay, that's fine.
All right. If we do not have an evidentiary Daubert hearing, do we need both days, or does it make sense to schedule everything for Thursday? What's the Commonwealth's position on that?
Stop doing that.
Absent that, I don't think there are a lot of matters before the court. The motion for clarification should take probably less than 20 minutes.
Okay.
And the motion for fees is a very simple discussion. So I don't think there's any way we'd need 2 days unless there is actually an evidentiary hearing, and then it'll take some time.
Okay. What do you say, Mr. Jackson? You're nodding?
I agree. I think if there's an evidentiary hearing, it's going to take multiple days. If there's not, I think we can pack everything into Thursday.
All right, because I don't want to waste everybody's time. I want us to get this case moving.
Of course.
So you will then file that motion to dismiss the following Monday or Tuesday, and we need to set it up for a hearing, if you are indeed filing a motion to dismiss.
I'm sorry. The motion to dismiss on which Monday or Tuesday?
After we meet next week.
Following week.
Yes. I just want to get a scheduling order going, so I need some of these dates, because we're going to need to schedule a hearing on that. I do not anticipate an evidentiary hearing on that, but I expect it will take time. All right, so the Commonwealth will have all of its discovery to you, it expects, by Wednesday the 5th.
That's correct.
Okay. We'll be back here at the end of next week. After you have that discovery, I can give you until February 11th, the following Tuesday, to file a motion to dismiss.
Yeah, they're filing a motion to
Commonwealth, I'll
dismiss.
give you until the 14th to file an opposition to the motion to dismiss. And let's hear it the following week. We're also going to have to, does the defense anticipate any evidentiary motions?
Yes, but I can't tell you exactly what those are, but in an abundance of caution, given the fact that we're expecting new information from the Commonwealth, I think the court can
All
safely
right.
say yes.
So February 21st, and I'll put this in writing, filing of all evidentiary motions, that can be an out-of-court date unless we choose that day to hear the motion to dismiss. Why don't we figure out what's your availability the week of the 17th? The 20th is actually the best day that week for us.
Yeah, she's set on going April 1st. April Fool's Day. That'll be when jury selection starts anyway.
Your Honor, that is that week of school vacation week. Both Mr. Jackson and I have young children, but one of us, I think, could probably be here on the 18th.
On the 18th?
Right.
Yes, Your Honor.
Okay. Well, all right, so I'd like you to get me, can the Commonwealth get me the opposition by midday on the 14th? So I'll have it to review over the weekend. I know you haven't seen it, so it's hard to figure out how much time you need. Is the Commonwealth available on the 18th?
I'm available anytime.
Okay.
I mean, we'll put all our effort into it. If we have a problem, we could let the court know.
Okay.
We'll do our best.
Okay. All right. Okay, so the 14th will be an out-of-court filing date. The 11th, an out-of-court filing date. So the motion to dismiss hearing will be on Tuesday, the 18th. Filing of all evidentiary motions will be the 21st. And that will be an out-of-court date. We will do the hearing on all evidentiary motions March 4th and/or 5th. I'd like you to block off both days at this point. And if we don't need them we'll try and, I don't want everybody coming in for just one motion. I know how much work you all have to do to get ready for trial. There's a lot of work I need to do to get rid of trial, but I'd like you to block off those 2 days because we can't have motions to suppress going on and on past that date. I'm going to need some time to review them and write them, so. All right. Can you all come back in on March 7th?
March.
You'll file all motions in limine. We'll have a final trial conference. And then we'll have to set up a date for what I anticipate will be at least a day, maybe 2, because it was last time on motions in limine. All right, so March 7th will be an in-court date. And file all motions in limine. And at that time, I want you to tell me how long you expect your motions in limine to take.
Your Honor, do you want those filed by the 7th? All motions in limine filed by that hearing date, the 7th?
Yes. And
All right, hold on.
Your Honor, do you want those filed by the 7th? All motions in limine filed by the
Motions in limine.
7th?
Yes. And we
didn't work.
On the 18th, which only gives me 2 weeks to decide them. Because we're starting the trial on April 1st. Jury Commissioner's Office has been fantastic about getting us as many jurors as possible. And we'll talk about impanelment, obviously, a little bit later. All right. All right. Anything else we need to discuss today?
Not on behalf of Ms. Reed, thank you.
No, thank you.
Okay. All right. Thank you all.
All right. So we have a lot to unpack here. All right. Oh, hold on. Let's eavesdrop.
You are muted. Goodbye.
Goodbye. Peace out.
That was Ali. Who's that?
Muhammad Ali about the George Chuvalo fight. He's a great fighter from Canada.
Yeah, I saw this and I can't delay to read it. So basically, all it's doing is just making the record.
Eavesdropping.
They're
Okay.
going after his opinions, and it's been stated now by the Commonwealth.
I want to see his clap back real quick. Here we go. This is my favorite moment.
Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your Honor.
Okay.
Thank you for the opportunity. The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Green has reckless
opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing.
I will tell you, like, I think don't tell Chat Daddy, I think I fell in love a little bit in that moment. A little bit of knowledge is dangerous. And then he's like, yeah, sure is. Hashtag. All right. So that was amazing. Favorite moment of the day. Okay. So there's a lot to unpack here. So let's talk about some of this, because I like to watch in real time. I only pause occasionally for like things that I can't shut up about. So there's a lot to unpack. Okay, so first of all, and I'll go over more of it in detail in the podcast episode for next week, but we have a lot of stuff that was covered. Cache, Shantae, sorry, focus Brandy, unmedicated Brandy. Okay, so oops, I just hit buttons. Stop pressing buttons, Brandy. That was really funny. It was really funny. Okay, sorry, focus. All right, so the whole thing with Gretchen Voss and her notes. We talked about that a little bit. We did pause and kind of talk about that because I know that I saw in chat some people were not kind of up to date on what some of that argument was. So we did stop and talk about that. I'll go into more detail about it, about the previous ruling and what's changed and what they're saying and all that stuff in the episode. But the Crash Daddy arguments, that argument is going to be pushed out. So we still don't know. That one is not a Daubert hearing. That one is a Rule 14, potential Rule 14 violation. So Brennan said he filed for the TUI letter, and anyway, next week, on Thursday of next week, we'll be back live again for a hearing, and they're going to talk about it then. They're going to try to figure out how to try to go about all of this without violating the specifications that the feds have given about this. Because remember, this is like the same thing, and I went over this in the last episode. This is like the same kind of thing that happened in the last trial, where the feds are saying, you know, you can't talk to the witnesses about this and this and this because it's an ongoing thing, whatever. So they, you know, Lally brought that up about discovery violations. Obviously, these are discovery violations that you can't avoid because of the way that the feds have worked out the stuff with their investigation. So it's not like a discovery violation that the defense was like, you know, F you, Lally, what, if anything, are you going to do about it? It's not that. This is stuff that they could not avoid. Their way to overcome that was to bring in the Crash Daddies for that voir dire. And I got to get out of the habit, because y'all know how I always say voir dire, like just laughing at the way that it's like my country accent. Like I say that so often, or said that so often, like just joking around, like when it's just the way I pronounce it with y'all or whatever, that I didn't realize I was pronouncing it like that sometimes in the podcast until somebody pointed it out, and they're like, sometimes you say voir dire and then sometimes you say voir dire. Did not even realize I was doing that. So I got to get out of the habit of saying that even when I'm joking. Okay, so anyway, remember they brought them in and talked to them outside the presence of the jury. They did the whole hearing on it because the whole thing is Lally needed to be able to hear the experts' opinions, what they base their opinions on, what information they were given, all of those things. So they brought them in. Lally was able to ask all the questions, get all the information he needed, because it's only, you have to be able to do that so that they can be prepared for cross-examination. You can't put an expert on the stand who nobody's ever talked to and then be expected to be prepared for cross-examination. So their solution was bring the crash daddies in, talk to them, let Bev eye them up and down while they testify, put Dimples on the stand and let him do his thing. So they did that, satisfied the, issues that Lally had with it. That way they can prepare for their cross-examination, and all was good in the hood. Now, Brennan has filed the motion saying that, he, the motion to exclude based on going through the same, discovery violations that they're expecting to have that they had in the last one. So next week, we will find out if they're going to be able to come to the same kind of agreement that they did, during the last trial, where they can bring them in beforehand or whatever. I don't know that they will be able to come to the same kind of understanding, because Brennan seems to be playing this more like he's just this is my opinion. I'm entitled to it. If you don't like it, there are other channels who have other opinions, and that's totally fine. But he, to me, seems smarmy, and maybe it's because I know he was a mob lawyer. Maybe it's because he actually behaves smarmy and says things that are super, questionable and smarmy, but he seems smarmy to me. So to me, it feels like he has filed this motion to exclude Dr. Russell. He has filed this motion to exclude Richard Green, and he has filed this motion to exclude the crash daddies. Commonwealth had 1,897 witnesses on the stand during the first trial. Defense had 4, and he is trying to exclude 3 out of 4 of them. Literally all 3 experts. Well, I count the crash daddies as 1. That's really 2. You know what I mean? Basically, he's trying to exclude everybody but Lucky. And that, to me, feels smarmy. Because it feels like, all right, if you disagree with Dr. Russell, all right, she's still allowed to testify. If you disagree with her methodology and all of that, obviously her experience is like lady's got some experience. She makes the rest of us look like lazy freeloaders. That woman has put in some hours doing all kinds of stuff. She's a brilliant, very experienced doctor. But if you disagree with her methodology, or if there's questions on that or whatever, okay, that's cross-examination stuff, whatever. So we went through that whole, 7-week-long Daubert hearing that never ended. And she's obviously allowed to testify again this trial. Now here we are, him trying to do it again with Richard Green. And I'm glad to hear Bev say that, because that was one of the things, when Bev allowed for Dr. Russell to testify, I was like, okay, well, there's no way she's not going to allow Richard Green, because this is not, and even with the way that he's, cranky hanky is saying in his filings, that Richard Green, he wants to exclude his debunked opinions. He even said, the whole thing is, he called it opinions. It's opinions. It's not the methodology that he has problems with. It's not the qualifications that he has problems with. Those are the 2 reasons to have the Daubert hearing. He doesn't have problems with those. He has a problem with the opinions. That's not for him to decide. He needs to sit on down, because that's not for him to decide. That's for the jury to decide. And I said this in the last episode, I don't personally think it, and this is just for me personally, everybody weighs evidence differently. For me personally, the 2:27 a.m. search is not a deciding factor on me seeing reasonable doubt. It's not. I don't care if it was at 2:27 or, 6:23 or, 2024. I don't care when the search was. To me, personally, that was not a deciding factor. For me, the whole, crash daddy situation was the part that carried the most weight to me, plus all of the things, all of the weird things, all of the butt dials, I got rid of my phones, all of the reports that had, well, the witness said this, but then the report said this, but then, the police said this, but then this wasn't done. All of the stuff with Proctor and what he tried to hide. And I don't care who, sits at their little computer trying to minimize this, like, oh, he just sent bad text. No, it is so much more than that. It is so much more than that. He decided that she was guilty within hours of being assigned the case, not only after he lied about having any kind of relationship to the people involved. He not only hid that, but then decided that she was guilty, is texting his buddies about it, and all of this while he had still not even gone to the crime scene. That's like the pure definition of showing bias. Like that's the kind of that's all the more reason to show he should not have been assigned as the lead investigator. Now, let's say it's a different investigator who came in and had done things the right way. Someone who didn't have a relationship with them. Someone who did go to the crime scene. Someone who did, explore all avenues and, evidence before he, zoned in on making a decision. Someone who didn't send grotesque text messages to his buddies. Let's say that it was that and that person came to that conclusion. That's fine, but that's not what happened. What happened is there's a biased lead investigator who made up his mind without having spent more than a few hours, driving around texting his sister and, talking to people and never even went to the crime scene. To me, that is a huge issue for me. That's a huge red flag for me. But the biggest thing for me is, aside from all of the stuff that all of a sudden doesn't make sense, the crash daddies. So, but some people might weigh the 2:27 a.m. search heavier than the crash daddy stuff. All jurors will always weigh evidence differently, and they'll put more weight in different things. So it's not up to Cranky Hanky to say, oh, these opinions are debunked and you shouldn't be allowed, the jury shouldn't be allowed to hear them. You can't say that a defendant is not allowed to put on a defense. Even the worst of the worst defendants are still entitled to a rigorous defense. Now, do some of those defenses piss me off? Yeah, I might have anger issues. I'll admit to that. I can admit that. But they still are entitled to it. And if they're not, if the worst of the worst aren't even entitled to it, then the ones who, look at the ones like Travis Rudolph, imagine if he wasn't allowed to put on a defense and he, obviously he was acquitted. He did have a defense and he had a great defense, team with Mark and Heidi. But, you can't, as the opposing counsel, determine what opinions the jury should be allowed to hear. That's not your job. That's not your job. It's not your, that's not what you're here to do. So it feels like he's going about this as a defense attorney instead of as a prosecutor, because, and I'm not down in defense attorneys. I have good friends that are defense attorneys, and I have a lot of respect for defense attorneys. It's a job that I don't know that I could do. For some people I could. For some people I'd be like, you suck. I don't, but that's part of it. And you know what? I applaud those who can. But we have seen a lot of trials. We have watched a lot of trials where we're sitting there watching these defense attorneys who are trying to, use technicalities and use things that, oh, that makes my client look bad. Let me try to keep that out. Well, he's got that mentality going into this. He's not trying to prove a case. He's trying to cut the defense off from the opportunity to present theirs. And that is bullshit. Sorry, language. But it doesn't matter if any of the jurors don't believe the crash daddies, or if they think, again, in this trial, that it's somebody hired by Turtle Boy or the insurance companies. It doesn't matter. They should be able to hear it. It doesn't matter if somebody thinks that Dr. Russell is, confused and doesn't know what she's talking about, and they don't think that those are dog bites. It doesn't matter. They still deserve, they still need to be able to hear that. And it doesn't matter if, they hear Richard Green and then Ian Whiffen and decide that they side with Ian Whiffen because his accent's cute. Doesn't matter. They still get to hear both sides. That's the way that this works. You hear both sides and weigh the evidence how you see fit as a juror. And to try to prevent that from happening, to secure a conviction, is bullshit. That's not how this works. So that's why I say he's smarmy. I think that his whole thing with, trying to exclude everybody he can is because he knows that they don't have a strong case as long as the defense is able to show all of this reasonable doubt. So he's trying to, cut out any reasonable doubt so that he can try to secure a conviction. And that's not how this should work at all. So, even the worst defendants should be able to get, even the worst defenses, like old David Marshall Murdoch, saying, I don't know, I just went to sleep. Don't know what happened. Yeah, I called and said I shot 2 women, but I don't remember. Okay, cool. You're full of shit, but yeah, cool. You get to say that. That's your constitutional right. You get to give your side. Do we believe you? No. We all rolled our eyes, but you go ahead. You do you, boo. Go ahead and tell us everything you want to tell us, and we will hear it. So, breezy hashtag value in my rehomed era. That's hilarious. That's amazing. He does have a smarmy way, 100%. Yeah. He's going about this not as a representative of the people of the Commonwealth. He's going at this as a smarmy defense attorney who just wants a win. And that's not what he should be there for. So we'll hear more about the Crash Daddies next week. The stuff with Richard Green is, I think he made some really great arguments. Alessi he's a good attorney. He is a really good attorney. Like, really good. I'm very impressed by him. And a couple notes that I made. A couple notes. I have to go back and I have to download it so that I can do the transcripts, so that I can then read it, so that I can comprehend it the second time around, because it's too much to hear everything while I'm also running all of this, which is why you always get more in the episode than you do in the lives. But just some notes that I noticed while we were doing that. The arguments that he made, that Cranky Hanky made in the beginning of his whole thing with Richard Green, was like, he changed his professional title. Bruh. Really? That's what we're going with? That's what you're kicking this off with? Okay. What, if anything, does that matter? Nothing. Okay, but all right, we'll go with that. Then the whole thing about methodology. If this man says methodology one more again, you know that meme where he's like, he's got the gun and he's like, say it one more time. That's how I feel with the methodology thing. It's like, I'm getting real sick of hearing that word. I'm going to be honest with you. I'm getting real sick of hearing that word. But okay, he wants to talk methodology. But he contradicted himself so many times, because he's talking about all of this stuff about how, Green is getting up there and first of all, he wants to talk about salacious. The stuff that he says up there is salacious. And he wants to talk about tone, but look at the tone of his, he literally titled his thing, Richard Green's Debunked Opinions. And you want to talk to me about tone, sir? All right, but we'll go with it. We'll go with it. I'm with you, Cranky Hanky. I'm with you. I'm following. I'm listening. But then he talks about how the whole thing about the X-ray analogy, being able to retrieve the data is not enough. You have to be able to interpret it. And there's methodology to interpreting it. They all had the same methodology. They just came to different opinions. So it's like, once again, you've wasted how many hours going over things that aren't real arguments. You're just trying to, it just makes you, you just sit down. Just sit down. Have a Snickers. Eat a moon pie. Drink a 7-Up. Stop filing motions, but whatever. So one thing that I thought was really interesting too is he said something about Green is suggesting that someone else murdered John O'Keefe. Sir, you are embarrassing yourself. Green did not get up there and say, based on Celebrite, somebody else murdered John O'Keefe. That didn't happen. So if you want to talk about salacious, sir, saying that is way more salacious than saying, based on the hashtag, hash value, this is, and Guarino not giving him the full report, which, okay, and that's another thing. Guarino, do we trust him? No. We saw what he did with the whole Sandra Birchmore thing. We don't trust it. We also saw that he did not follow protocol and give the full image to the defense. They had to ask for it, 3 times? So, no, sir, we don't trust Guarino. Which is probably why Guarino was on the stand. Wasn't he the one on the stand that was like, kill me? Well, Green is not suggesting that someone else murdered John O'Keefe. He's suggesting that based on his opinions, the hash values, which Alessi did a great job of explaining that, it's like a fingerprint, like a signature to say this is valid or whatever. He's saying based on that and not getting the data from Guarino the way he was supposed to, and this and this and this, and this shows as deleted and whatever. So it either has to be deleted by the user or it, was deleted by somebody else. He didn't say, based on the way that I read the Celebrite information, somebody else killed John O'Keefe. It's ridiculous. He said Mr. Green is just a vessel for the third-party culprit defense. That's his biggest issue. He's trying to prevent any third-party culpability defense. And honestly, I said this in the last episode too. You don't want to have that, more power to you. But I think that honestly, some of it became distracting. I think that there's reasonable doubt. And I think that, and I know I'm for those of you who actually listen to the podcast, you've already heard me say this, but I feel like it did some shifting of the burden of proof, which it's not supposed to happen. It's not how it's supposed to work, but we've seen that this has worked like this. When the, third-party culprit defense is brought up, then it kind of turns into a shift of the burden of proof, because now people look at it like, okay, I don't believe this. And that's one thing you see on social media all the time too. You're like, I can't believe you believe in a conspiracy with 400 people. Did I say that? Or did I say that I see reasonable doubt? I hear so many times and see so many times people are like, oh, the defense hasn't proven anything. The defense doesn't have to. That's not how this works. The prosecution has to prove it, and they didn't do that. So it doesn't matter if I believe that one person did it or if I believe that 500 people throughout the, Boston area did it. It doesn't matter. What matters is that the prosecution did not prove it. There is reasonable doubt. There is another explanation that I don't have to know what that explanation is, but I have to know that there are other explanations that could explain the evidence that was presented. That's how I see it. That the way that they have said what happened, the way that the prosecution said this is what happened, when I look at the evidence, I do not look at what they're saying and say, yep, that's the only reasonable explanation. That's the only reasonable way that you can explain all of this. Because there's too many things that don't make sense. If you have crash daddies telling you, nope, that's not consistent. If you have a dog bite expert or doctor who's knows all this stuff about dog bites. She's not a dog bite expert, she's a doctor. But only doctors can testify about the causality or causation of injuries. So she's a doctor and she has experience with dog bites. If she's saying that they're dog bites, I don't have to agree with her. I could think, you know what, it's more likely that it came from a snowplow or whatever else I think. Not a car, the way they said it. That doesn't make sense to me. But I could think that it's anything else. It doesn't matter. I don't have to agree with her. But if I look at that and I'm like, yeah, that's reasonable. I don't think that happened that way, but I could reasonably see that could happen. That's reasonable doubt. I don't think that people understand, especially when it comes to this case, that you don't have to buy into one full theory or the other full theory. This is not a, you pick this or you pick this. It's either you buy into this full theory or you don't. That's it. You don't have to know what happened to John O'Keefe to know that this is a not guilty verdict. You don't have to know, who Higgins was calling on his phone or, why his phone ended up at an army base or, why none of the times make any sense and nobody seems to know what the heck is going on. You don't have to know any of that. The only thing that you have to know is that the story that they have presented us about what happened to John O'Keefe does not line up with the evidence that they presented us about what happened to John O'Keefe as the only reasonable thing. That's it. That's it. And you can't tell me that the only reasonable conclusion based on that, you can tell me that. I'll disagree with you. But for me, I don't look at the evidence and think, yep, solid case. There are plenty of cases where I do look at that. And I'm like, yep, he gone, she guilty, whatever. This is not one of them. And I think until they can fill in those holes, there's going to be reasonable doubt. And the way that things have played out, they're not going to be able to fill in some of those holes. They can present their theory, and I could see it as, yeah, sure, maybe this theory is it. But you cannot convict somebody based on, yeah, sure, maybe their theory is it. That's not how it works. So, I don't know. We'll see. We'll see. The hash signature value is going to be one of the biggest arguments, I think, when they're going through that in the next trial. We'll hear a lot more about that during that. We've heard about it before. This has been an issue ongoing since day one. But I think we're going to hear a lot more about it. And also, it is kind of, it comes across as really sus to be like, oh yeah, you know, you can only rely on, all of his opinions are debunked because Celebrite says so. Well, okay, the opinions came from Celebrite, but that's all changed. So he's debunked because of this version of Celebrite. So just ignore that version. That version's not reliable, even though that's what we've used to put numerous people in jail. Don't just ignore that. That's not reliable. But now this is. That doesn't look good. Doesn't look good. So, I don't know. I think Brennan needs to be rehomed. He's annoying me, but you know, what do I know? Especially because it's the timestamp still shows on the other stuff. It's not just Celebrite. They're wanting us to focus only on this new version of Celebrite because it's the 227 does not show up on this version. So they're like, ignore all of these other things that show that the 227 search is there. Ignore all of those. The only thing that's reliable now is this one. It's not how it works. It's not how it works. So I predict that Green is going to be allowed to testify. If he's not, it would be a huge appellate issue. And I think that, you know, I think that's like common sense. I think that Brennan is, I think, hoping that his arguments will pick up steam. Because, you know, there's those people who, like, they won't listen to anything the defense says. It's like after Brennan or Lally stop talking, then they don't hear anything else. So they take that and run with it. So I think that Brennan is actually hoping for that. Like, I think that he's hoping for the nonsense stuff that he says to be, like, taken and run with it. Andrea Burkhart tweeted earlier, honestly, now I kind of want the Daubert Lanigan hearing so I can see Mr. Alessi turn Ian Whiffen into a defense witness on the stand. That would be something. That would be something. It's interesting, too, the 4,056 searches on Jen's phone, and the only one that's showing deletion was the Hoslong to die in cold. And the tab number for the Hockomock Sports was a different tab number. Stuff like that is very interesting. And see, the jury will hear these things, and again, they don't have to pick one version or the other that they 100% believe. All they have to do is hear different explanations, different interpretations, and then, you know, add that to their full overview of, is there reasonable doubt or not? Yeah, that was hilarious. So do we think that Trooper Greeno deleted the search? I don't know, because I know that they said that the old version that they were using didn't show it, and then the new version did. Honestly, the way that Greeno's history plays out, I don't put anything past him, but I also would not want to accuse him of that. He has lost credibility. So it's like, I just, you know, what can you do? It would be funnier if he had said that Hanky was spending too much time on Twitter. Did you see the discovery notices that he filed? It's like he's filing like anonymous emails and anonymous 4-page. Bruh. That's not... Okay. All right. So this is what we're doing now. Murder trial. Let me file this anonymous email. Plus, they were not given a full file, so I guess that's a bigger issue. That's a much, much bigger issue, yes. Much, much bigger. and they had to be asked multiple times. Multiple times. So, so we'll see. A lot to, we still got so much to go. All right, so we will be back together next Thursday. Right? Yes, Thursday the 6th. We will be back together. And then again on February 18th. So, oh, that'll be right after. I'm going to Daytona 500. I've never been. Yeah, Chat Daddy is, he got us tickets to Daytona 500, so we're going to that. So that's on Sunday, and then that following Tuesday we're back in court. So the 6th and the 18th. And then again, the 27th, is Vallow still starting on the 27th? I think so. I'm planning on streaming that one. I think it's still, I think right now it is. I have to double check and see if it's changed, but. Sinbad 33, remember 14 whole months. I've missed you all. You look wonderful, Brennan. Thank you. Thank you. Thank you. I have missed y'all too. Oh, Vallow is end of March. I was thinking it was end of February. Oh, dang. So it's going to be going on at the same time as Karen Reed? Because I know it was originally set for February 27th, right? They did that with Daybell, Chad Daybell. Because I originally was trying to stream both because I had streamed Lori Vallow. I wanted to stream Chad, and I did the first few days, but then trying to do all day streaming of Karen Reed plus the podcast, and it was too much. Too much. I know, can't handle Karen Reed and Vallow at the same time. I know, especially because Vallow's representing herself. I really want to see that. So, I don't know. We might just have to do highlights of that one, or maybe go back and watch it after Karen Reed or something. We'll see. We'll see. I know, someone's going to have to push their try back. Well, you know it ain't going to be Bev. You know it ain't going to be Bev. But I have an exciting collaboration in the works for some Karen Reed stuff too when the trial comes. So I'll tell y'all more about that soon. Big stuff happening. Big, big stuff happening. All right, y'all. Oh, it's Lucy. I was like, what is that noise? It's my dog. I have a lot to do before Chat Daddy gets here. So I am going to jump off of here. Who's live? Is there anybody live that we can raid? Let's see who's got what going on. Support our fellow YouTube friends. Let's see. Let's see who we can support. Edit. Redirect. Oh, RA is live. Okay. I'll send us to RA. All right. So RA is watching Colin Griffith. All right. I'm redirecting us to RA. So let's go to Baker's not showing that he's live. Let's see Baker. So, all right, we're gonna so hands and feet inside the portal. Get your life together, ponytails, all that stuff inside. We are going to go through the portal over to RA and tell him hello and send him some love. If you have not listened to the recent episodes of the podcast, please do so and let me know what you think. The David Marshall Murdoch 3-part series plus the 2 bonus episodes, and then the Letitia. Like I said earlier, if y'all missed it, I have redone those Letitia episodes because they were just the recaps of the audio. It was like the audio version of the video recaps I was doing. So I have gone back and redone that whole series, and there's 6 parts to it. The 7th and final part will be out with Dr. Russell's testimony. Not Dr. Russell. Dr. Lewis' testimony will be out either next week or the following week, depending on what all I can get done with Karen Reed. But go back and listen to those if you could, and let me know what you think. I miss y'all. I'm glad to see you, and I will see you all next week. Right? Yeah, next week, next Thursday. All right.
I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel. And
Good morning.
Goodbye, good people. Now, how the heck do I get out of here?